CCTV access gate and on-site biodiversity net gain at Burcot Farm, Burcot, Abingdon, Oxfordshire, OX143GY3GW. Please can I remind everyone to make sure that their phones and other electronic devices are either on silent or switched off. So this is the second day of the inquiry. Yesterday we started hearing evidence from the council, and so we will continue with the cross-examination of their witness today, and starting with evidence from provided with hard copies of that. Yes. Another thing that dawned on me overnight was in terms of the, you are not a drainage engineer, Mr. President, and therefore I didn't know whether you needed to get a statement from your flooding or drainage engineer. I don't know if they could do that to specifically answer. I mean, it was a very specific question about the flooding and drainage. I mean, if you feel capable of answering it, then fine. But I didn't know whether you wanted to get a statement addressing that, particularly, and whether that can be done before the inquiry closes or not. I don't know, but if you want to have it.
So, I mean, we were going to deal with it by referring the inquiry to there was an update to the flood risk assessment that went in with the appeal that took place after that flooding.
Right.
And the council has reviewed that.
Right.
And the council will be aware of what's going on. So we were going to deal with it that way. But
if that's fine, but I would say if you needed to,
we'll try to ask them. I think it might be
a
bit difficult today, but when we stop at lunchtime, I'll talk to my clients.
Yeah, I mean, I say just if you feel if you've got enough information, that's fine. But I was just aware that it was a very, very specific query, and I know that we haven't got a drainage or drainage engineer sat around the table.
I don't know if it's helpful, but that's entirely the approach I thought my learned friend would approach the issue.
Right. Yeah.
I think it's entirely sensible.
Right. Yeah.
I think it's capable of being resolved in that way without a specific question being answered because the assessment's been conducted. But,
right. Yeah.
But there we go.
Yeah.
We'll have a discussion.
Yeah.
Thank you very much.
Are there any other housekeeping points?
Yes. Can I just mention there will be a fire alarm test at 11:30.
Right.
It's quite loud.
Right.
But it will be a test.
Right. So other than 11:30, we follow you right, Bill?
Yes. Absolutely. Yeah.
Right.
There's one document that Mr. Fields would like to refer to.
Right.
In his evidence following the evidence of Mr. Reynolds yesterday, which is just the DEFRA statistics for how much solar farmland is grazed by sheep.
Right.
And I've sent that to Mr. Clapp this morning. I don't know if he's still looking at it or if he's happy for it to go in, but I'm not going to take Mr. Reynolds there. It's just something Mr. Field wants to pick up.
Right. Yeah.
I'm told there are 2 paragraphs in the document that Mr. Field wants to refer to. Yeah. I'm happy for the document to be relied on that basis.
Right. Yeah. Thank you. So,
send it to him.
I mean, if it comes up today, depending, yes, I might not. If it's not onto the website, then I won't be able to.
I think it will come up today because Mr. Field's probably going to be asked questions about it. So
I can put it on the website as soon as I receive it, but
I'll send
it can. Yeah, I can.
Right.
I can print a copy. It's fine.
It's quite a small point. It's just a couple of paragraphs about the numbers.
Right. Yeah.
But we'll try and get it on the website.
Yeah.
Thank you.
And just before, are there any interested parties who wish to say anything and who weren't able to attend yesterday? No. Right. Well, on that basis, Ms. Toby, if you'd like to continue the cross-examination.
So just to get up some core documents to start with. So you'll not be surprised to hear we're going to the site selection report.
318
or 19, depending on you said.
Yeah.
Mine in paper copy for the same reason. EN3, which is full document 8.4.
Yeah,
I think this might be one of the ones. I know this is all there. You don't have to click through.
It's one of the confusing ones where it goes 831, doesn't it? Before it gets to 8, it doesn't.
Oh, right.
It's just the way it's numbered, because it sees 2.1 as rather than 21.
Yeah.
It sees it as 2.1. So 8.4 is quite a long way down. But I've got it now.
The local plan, which is 5.1. And then Mr. Cusson's proof and rebuttal. And there might be a few appeal decisions we need to go to in the course of it. It sort of depends how the answers go. So I think we'll start with that. So Mr. Reynolds, there's some way to go still with this. But can I just at the start ask you, as the inspector said at the very outset, if we can try to answer the questions yes, no, and then clarify, and we might move a little bit quicker today. That's all right. Thank you. So just to quickly recap where we got to yesterday. So we agreed there's no requirement for a sequential approach or consideration of alternatives in national policy or guidance.
Yes.
And where policy requires a sequential test like flood risk or town centre development, it does so clearly and it sets out a methodology for doing so.
Where a sequential test is required, yeah.
And we also said there's 7 doesn't have a requirement for a strict sequential test like flood risk or town centres. But you said nonetheless it requires some sort of sequential approach. And because of that, you think the appellant conflicts with it and you give significant weight to the use of BMB on that basis.
That's fair.
And I just want to double check, because I was rereading my notes from examination in chief yesterday. You don't say there's a separate harm to BMB and DES 7. That's one lot of significant weight to weigh in the planning balance.
Well, DES 7 deals with use of BMV, so yes.
Yeah. I thought that was the case. That's what
Yeah.
you said in your proof. I
Yeah.
just wanted to double check. So now I want to look at this particular scheme and some of the factors that might go into whether a reasonable balanced judgment that use of BMB is justified here. And first, we can agree that the appeal scheme would bring about no permanent loss of BMB or affect the ALC grade.
Yes.
And we can also agree that arable farming can return on decommissioning.
Yes.
And because there's no significant permanent loss of BMB, Natural England, who provided a consultation response, stated expressly that there's no objection.
No objection on the basis that there's not a permanent loss, yeah.
Yeah, and for the inspector's reference, that consultation response is core document 4.15. And that's an important material consideration for this inspector, isn't it? Natural England's consultation response.
It's a material consideration, yes.
I mean, they're the statutory consultee.
They are, yes.
And that she can give that considerable importance and weight.
It's a material consideration that can be given weight. It's a matter for the inspector how much weight she gives it.
Well, as a matter of law, when there's a statutory consultee giving expert consultation advice, considerable importance and weight has to be accorded to it.
No, I'm not a lawyer.
Okay, well,
I can't
so
answer
you don't
questions
think
on the
it's
law.
an important consultation response?
I'm saying it's a material consideration, yes.
And what weight do you give it?
I give it moderate weight.
Why have you not said it gets more weight than that?
Well, because
the expert statutory consultees review.
Well, if you want to go through it, we can go to it and go through it.
But you say moderate rather than significant weight.
I don't. Yeah, moderate weight is what I would say.
And why? Why is it not significant?
Well, because it's a standard response that you see typically on solar farm proposals at this scale. As you know, they're a statutory consultee when they're over a certain size, and it tends to be the same response that comes back each time, which is a standardised response.
And the reason it's, it goes into some detail as to what's proposed. The reason it's a standard response is because solar farms don't cause any loss of BMB. So Natural England is not concerned about the BMB impact.
Well, I'm not sure it's fair to say they're not concerned about the loss of BMV. They don't object on the basis that it's not a permanent loss, but they do defer to the council. We probably better turn it up.
Let's take it up and have a look. So document 4.15. You got that?
Bear with me a second. Yeah, I have it.
So we see the box there at the start, summary of Natural England's advice, no objection. The first paragraph's there about designated sites. And then it says the proposed development would result in the temporary loss of over 20 hectares of BMV. Natural England advises that soil management is considered, and its advice on soils and agricultural land quality. So notwithstanding that Natural England was aware there was a temporary use of over 20 hectares, it has no objection to the scheme.
That's its summary advice, yes, in that box. Top.
And then if you read down the second paragraph there, we consider the proposed development, if temporary described, is unlikely to lead to a significant permanent loss of BMV as a resource for future generations. This is because the panels would be secured with limited soil impacts. And then it says, although some components such as construction of the substation may permanently affect agricultural land, this would be limited to small areas. And you're aware here that the substation is proposed to be removed, yes. So that's not difficult. And then it says, during the lifetime, there would be a reduction in agricultural production. Your authority should consider whether this was an effective use of land, in line with practice guidance, which encourages the siting of large-scale solar on previously developed and non-agricultural land. You see that there?
Yeah.
And in this case, the council doesn't suggest this could be sited on previously developed or non-agricultural land.
No, it doesn't.
So we've met that there.
You've met that, yes.
Yeah.
But my point is that the paragraph that starts, however, it's not a ringing endorsement of the scheme. They do point out that there'll be a reduction in agricultural production over the whole development area during the time in which it's there. And they're essentially saying, well, that's a matter for the council to consider. So it's not a support, it's not an objection, it's an objection.
It's no objection.
But it's qualified.
And the other point Natural England make is that the soil should be protected. And you're aware here that there's a proposed soil management condition 10.
I believe, yes, I think so. I haven't been dealing with the conditions, so I have vaguely seen it, but I studied it in detail.
And thinking about what you say is the temporary reduction in production, there's no national or local policies that require agricultural land to be farmed, and no policies that control or determine the type of agricultural use taking place on land.
No, correct.
And so even if planning permission were refused here, there's nothing that prevents the landowner from using the site for grazing or in fact leaving it fallow.
No, that's correct.
And you're aware also that the appellant proposes the land would be used for seasonal sheep grazing?
Yes.
And I think you made the point yesterday that that's not secured anywhere. And I know you said you haven't been looking at conditions, but there is a condition for a landscape and ecology management plan. And the current plan covers sheep grazing, doesn't it?
From recollection, it refers to an and/or. It talks about cut or grazing. I don't think it, from recollection, we'd have to go to it. I can't recall. But
there's a new plan proposed under the condition, a detailed LEM. And if the council thought necessary, it could include within the condition a requirement for that LEM to include how the land would be grazed by sheep.
Well, it's not been offered as something by the appellant, but they're happy to have secured, is my understanding. So the council has put it in something to be secured. They're saying we may do that, but they're also saying we may cut the land. It's an and/or.
What the LEM says is that the proposal is seasonal sheep grazing to cut the land. That's what the appellant says it intends to do. If the council wants to secure that, it can put a requirement in the LEM condition.
Can you take me to it? Can we go to the LEM?
Well, the LEM is not the one that's proposed to be secured. There's a condition for a new.
So it's not in the core docs. You're talking about a LEM that I haven't seen.
No, sorry. The LEM is in the core docs, but the condition requires a finalised new detailed LEM to be secured. So the one in the core
right,
docs
okay,
is not.
Sorry, that's a draft LEM. Right,
yeah, it's a draft LEM.
Okay, so it's draft. So, well, if the appellant is happy for that to be secured, then I expect the council would be willing to secure that through condition. Yeah.
Okay. So we looked at the evidence yesterday and thinking a bit more about this conversion from arable to pasture. You accept that can have a number of beneficial environmental impacts in terms of soil organic matter, soil organic carbon, and soil moisture.
Yes, we don't contest that.
And the second point I want to make about the justification for the use of B&B in this case is you're aware that this scheme has been designed in a way that avoids the Grade 2 land in the wider area that was originally surveyed.
Yes, there's land to the north east which is excluded. It's Grade 2, yes.
Yeah, so I think the original survey, and this is set out in the agricultural statement of common ground, identified a 93 hectare area, and 22 hectares of that was Grade 2, and the vast majority of that is not included in the appeal scheme.
Yes, only 4 hectares, yeah.
And stepping back and looking at the wider area, you're aware, I think you mentioned yesterday, 42% of all farmland in England is B&B.
Yes.
It's not a rare occurrence.
No.
And Mr. Field's evidence, which I don't think you contest, is that there's actually some 36,000 hectares of B&B in this district alone.
Yeah, I haven't counted, I don't contest it.
Here we're 57 hectares, so that's just 0.15% of the total.
I'll take the maths at face value.
Yeah, that's a very small proportion, isn't it?
It is, yes.
And I think you also mentioned yesterday you're aware that this is a district that has a higher prevalence of B&B than nationally, and Mr. Fields estimated it's 57%.
Yes, he has.
Yeah. So next I want to look at the site selection report. So if we take that up.
Yeah.
So we've agreed that there's no local or national policy requirement to carry out a sequential test.
No national requirement.
Or local. That there's not.
Oh, so sequential test.
Yeah.
Yeah. Okay.
But we can also agree that a lack of sequentially preferable sites can be a benefit in the planning balance.
Lack of sequential sites could be a benefit in the planning balance. Well, it won't be in this case, in my view, because we say there are alternative sites.
But in principle,
if there were no other sites, I mean, it depends how you want to deal with benefits, really. If you want to carve benefits up in the same benefits up into lots of different pieces, then you might argue this. I would probably treat it in the round. But in principle, yes, I guess.
Yeah. And I mean, that's the basis on which Mr. Cusson refers to this sequential test. It's to justify the benefit, the significant weight he gives to the benefit of a lack of alternative sites available to deploy the grid connection. So that's why we're looking at it. And in terms of approach, there's no prescribed way to carry out an alternatives assessment in either local or national policy or guidance.
No.
And so without any specified methodology, such an assessment by necessity engages planning judgment at every stage.
Yes.
And an assessment of alternative sites should be proportionate and pragmatic.
Yeah, the local policy requires consideration of reasonable alternatives.
And when a site's being chosen at the outset for a solar farm, there can be many reasons why it might be unsuitable. There might be serious ecology issues, heritage, amenity issues. There's a whole range of things that go into that decision.
Correct, yeah.
And another important question when you're selecting a site is whether there's a willing landowner and whether the land can be assembled in a commercially viable way.
Yes, yeah.
So all of those are factors that go into site selection, not just B&B. It's not some overriding consideration.
No, it's one consideration amongst others, but it's an important, very important consideration.
And in terms of approach to site selection, we can also agree that every solar or indeed battery project has to start with a grid connection. If you don't have a grid connection, there is no solar farm, there's no battery.
You do, yes, you do need to have a grid connection, yes. But we should start with that.
Well, if we, this is where I wanted to go to EN3, which is core document 8.4. If we could go.
Yeah, but no, I'm not there. I've got a lot of tabs open. Some of them helpfully label the core document. Some of them don't.
Yeah.
Right, I have it. Yes.
So if you go to 2.10.22, which is on page 90.
I have it. Yeah.
So you see there many solar farms are connected into the local distribution network, which we are here.
Yes.
The capacity of the local grid network to accept the likely output is critical to the technical and commercial feasibility of a development proposal. You see that there?
Yes.
And if you go on to 2.10.25, you see to maximise existing grid infrastructure, minimise disruption, and reduce overall costs, applicants may choose a site based on nearby available grid export capacity.
I see that.
Nothing in that you disagree with?
No, I think they have to, don't they? If you don't have a site where you can export the electricity to, then my view is to ensure that you don't end up in situations where applicants are being told they must consider land where there's no point of connection, essentially.
And do you accept that grid connections are a constrained resource in this country and that there are serious connection delays for projects currently seeking new connections?
As a national picture, yes,
Yeah.
There's evidence before the inquiry.
And in fact, locally, there's evidence before the inquiry that the waits in South Oxfordshire for new grid connections are now about 10 years.
Can we go to that?
Yeah, so that's Appendix 2 to Mr. Cussin's proof. There's a grid connection summary statement from the applicant.
It's not a page, sorry. It's below the heritage statement, isn't it?
Yes, the one after that. So I'm on PDF page 13 of the appendices.
Right, yeah, annoyingly mine doesn't have page numbers, but I've got it, don't worry. But you'll have to tell me which page of the actual document.
So there's the first page is Appendix 2, the title. Then there's a page with a map on it, and then we're on the page after that, some paragraphs titled Rapid Connection Timeline.
Yeah.
And what it says in those 3 paragraphs is that you see at the bottom of the second paragraph, all applications for new connections in South Oxfordshire will be offered a connection date post 2036. But it explains that because this application was made some time ago, there's the ability for this scheme to connect within 2 years. See that there?
I see that, yeah.
And you haven't put anything to rebut that evidence?
No, I haven't. The only thing I would say, of course, is that they are upgrading Cowley substation network, and they are, nationally, they are obviously looking to improve and increase the level of capacity that can be taken. So that's the situation now.
Yeah.
But it's impossible to reach the government's goal unless the network is improved significantly, as well as bringing forward, obviously, renewable to enable those sites to come forward. So that's
Absolutely.
The position now.
Absolutely. Yeah. They're trying to make changes. We have no idea how long those will take, the impact they'll have, but the government has recognised that the grid is a real problem, hasn't it?
Yes.
And you don't disagree that in light of the urgency of net zero and that real problem of grid connections, it's important for capacity to be taken up wherever it's found.
Yes.
And the site selection report doesn't go in to looking at other points of connection, and I know that's a criticism you've raised. You mentioned in your proof the possibility of connecting into the 132 kV line. And I don't know if you're aware of the process of how you get a grid connection at a specific point. But are you aware that when a developer applies to the DNO to connect to the grid, the DNO tells them where they're going to connect? So we weren't offered a 132 kV connection here. We could have been and we weren't. It's up to the DNO to tell you where you're connecting into the grid.
But the Sutton, the Courtney site, the 2024 current pending application does connect into the OHL.
So it was given a different grid connection by the DNO. It's not up to the applicant.
I don't know when your grid connection was actually sought. Some years ago, I understand.
I understand some years ago. Mr. Cusson might be able to confirm that. I'm aware that projects on this site have been.
It's granted to Burcot Solar Farm Limited.
Right.
That's who made the application.
Yes.
That's who it's granted to.
Well, I don't want to answer when I'm
not
exactly sure, but we'll get Mr. Cusson to clarify that in his evidence.
My question, it was only really to understand, well, is this a statement in relation to then when it was originally sought? Is it a statement by the appellant?
Yeah.
It?
We'll ask Mr. Cusson to clarify that. And you're also aware that once you secure a grid connection, once you pay the fee to the DNO, that's then tied to a specific site and it can't simply be transferred elsewhere.
Yeah.
And so for that capacity to be used, the whole process would have to start again on another site.
Yeah, you have to, in this case, Burcot Solar Farm Limited have to use this capacity, presumably at Burcot Solar Farm.
Exactly. And when we're thinking about reasonable alternatives, part of that consideration must be the point in time at which those purported alternatives could come forward.
Yes.
And that's partly because otherwise you'd be contributing to meeting a different need and probably not to meeting the same need in 2030 for clean power. It's going to be a later need that you'll meet.
Yeah, the need is going to be there, isn't it?
But it would be it's a different need.
It's a need for energy to feed into the grid. I take your point that this site could deliver quickly. Your point is it can deliver towards meeting the 2030 targets. Later connections won't. They'll deliver later and they'll meet a need later. Is that? I think that's what.
Yeah.
If you're saying that, I agree with that.
And keeping all that in mind, it is a reasonable approach to considering potential other sites to focus on where connection capacity has been offered.
You need a
yes
connection.
Or no?
Yes, you need a connection, obviously, to bring forward so strong.
And doing a site selection exercise across the whole of England wouldn't be proportionate in that context.
No, I don't think that would be proportionate.
So the second criticism you make of the site selection report is that you say the radius is insufficient. And here you're aware the scheme connects to the Cowley substation, which is 5 kilometres to the site as the bird flies, but the grid connection has to wind around and it's up to 8 kilometres. And you're aware, aren't you, that the longer the cable route, the more likely the project's going to encounter physical barriers like river and rail crossings, land ownership issues, and that can significantly impact the cost.
That's logical, but typically they'll use highways.
And it's explained in the site selection report, and I think you noticed this already yesterday, that the development's feasibility work ascertained that an approximately 8-kilometre cable run was the furthest viable one for this project.
That's what we're told, yeah.
Yeah. And you've provided no technical analysis to dispute that, have you?
Well, with respect, how on earth could the council provide technical analysis around the viability of a private project being brought forward by a private developer with private relations with the farm? The council, we have raised it to say that the evidence hasn't been provided, so we don't know. That's what I'm saying. But no, the council couldn't possibly have the information to produce that evidence.
The council hasn't put forward alternative evidence. That is the appellant's evidence. It's not required to provide any other commercially confidential information about costs or anything like that. There's no requirement to do so. In your proof, you point to one scheme that's located 13 kilometres from the connection. But you are aware that the actual cost of the grid connection can vary wildly from case to case. It's not a standard plug-in cost.
Well, I don't know exactly how much it might vary. It's the same connection being sought in the same substation. So if someone asked me to pay just rather than say twice the price for something that I knew someone else had paid half the price for, I would have a problem with that.
Mr. Custer might be able to explain this a bit further, but the costs of the connection do vary. They depend on different schemes have to carry out different types of upgrades. There's different agreements in place depending on the date at which you've connected is a very important point that timelines change as well. And in fact, we can see from the appeal decisions that many inspectors have considered a far shorter radius to be a reasonable one for a site selection report.
I'm aware that they have, but again, I would say we don't have any information before us as to what the evidence that was being put forward, and there may have been viability evidence adduced in some of those cases. I don't know. We don't have that information before us. All I'm doing is pointing out that an alternative developer is proposing a significantly longer cable connection, and the price of the cable of the connection itself might change, but of course that would be factored into the deal you do with the landowner, private developer.
And we're not, I don't think we need to go there, but just for the references, CD 7.60 Walsall case, we can go there if we want. Paragraph 32 was a 2 kilometre radius. And Thaxted CD 7.23, paragraphs 118 to 90, 4 kilometre radius. There was no technical viability evidence put before that inspector. And she was satisfied that 5 kilometres was a reasonable approach.
Yeah, well, I can agree that the inspector was satisfied that it was a reasonable approach. What I can't agree is the details that were put before the inspector to reach that conclusion.
The next criticism you make is that the site selection report, as regards use of BMV, doesn't go into detail on the other provisional grade 3 areas. And can we agree this, that if a site's provisionally grade 3, then the only way you can establish whether it's BMV or not is through intrusive and costly soil sampling?
You would need to do soil sampling to establish, yes, whether it's grade 3A or 3B.
And you'd have to get permission from private landowners who may require compensation or could hold the scheme to ransom.
Well, yes, you would need to do, but you are, of course, potentially offering the opportunity for a more lucrative use of their land, financially speaking. So there's an incentive there for people to allow solar farms to be developed on their land. Otherwise, we wouldn't have all these solar farms coming forward.
And you're aware that these studies are done at an observation density of 1 boring per hectare.
Yeah.
So that is a vast number of borings if you're going to look at all the grade 3 land in the area, isn't it?
Well, yes, if you're going to look at every piece of grade 3 land, the problem here is that if you chose any piece of grade 3 land and put a pin in a map, it's going to likely have less BMV than the appeal site.
Well, that's a good example, because the appeal site is provisionally grade 3 and turns out it's all BMV, and this exactly the same could happen with any other BMV site on the map, couldn't it?
Could be greater levels of BMV, there could be lesser levels as well.
And the only way you can tell is by these intrusive.
In terms of grade 3 land, to assess it, you do need to, yeah.
And actually grade 4 land as well, you can't definitively know if that's BMV or not until you do.
Yes, and they're predictive maps, and they would be assessed, as part of that process of establishing for certain exactly what they are, but they are a starting point.
And practically, it's not reasonable or indeed proportionate to expect those seeking to develop urgently needed renewable energy to sample all grade 3 land in an area of search, is it?
Well, I don't think so. It depends on how big the area of search is that's agreed, I guess, as to whether or not it would be reasonable to ask them to.
So in the 8 kilometres here, it's not reasonable for an applicant for a solar farm to assess with intrusive soil boring. Yeah, yes or no? Is it reasonable?
It's not reasonable, but I don't think it's reasonable not to do any sampling of any alternative sites.
And is there any requirement anywhere in planning policy or law to undertake sampling of alternative sites?
Well, I come back to DES 7 and the requirement to consider whether or not it's the most sustainable choice from reasonable alternatives. Now, to my mind, as part of that exercise, I would think you need to consider reasonable alternatives.
It doesn't say anything about soil sampling, about getting agreement from other landowners to test their land. There's nothing about that.
No, it's a matter of plain judgment as to how far you would need to go. I'm saying that I don't think ignoring all the grade 3 land is a reasonable approach if you're trying to identify the most sustainable choice, or ignoring lots of alternatives.
And I have read the appeals before this inquiry. I'm not aware of a single one where an applicant has done soil sampling of other people's land. That's simply not something that people do.
Well, you need obviously the permission of the landowner to do it, of course. I mean, the timing of it. I mean, your soil report was done after you'd secured the connection to the site. You secured the connection to the site in August 20. Burcot Solar Farm Limited was incorporated in July 23. You did a soil survey after that to understand what the grades were of the appeal site. August.
Mr. Field's shaking his head at me. I'll let him talk about the dates of the original soil survey here. But the point is no solar farm that has got permission through appeal has done soil sampling of any other.
I don't know.
Well, yes, you said you hadn't read the full documents.
Well, even if I'd read every appeal decision, it wouldn't tell me necessarily the level of sampling that's been done. You'd have to go into all of the background information to reach that judgment. So I don't know, is all I can say.
And you do refer in your proof to the Lullington appeal, that's right,
yes.
Isn't it? And the point you rely on is that the one you make now, which is the inspector there appeared to consider that the appellant could have carried out soil samples of other alternative sites. They hadn't done so.
Yes.
And you're aware that very unusually, the weight to the written ministerial statement was not a controversial issue in that case. The parties agreed that that was the right test.
Yes, the appellants accepted it was the right test.
It is a controversial issue here, and we don't accept that it's the right test.
No, I appreciate that.
And that Lullington appeal also predated the Bramley High Court judgment that said there's no requirement for a sequential test for BNB.
I believe it did. You'll have the dates, but I believe it did.
And I know the Lullington case itself was upheld by the High Court, and I think your barrister wants to refer Mr. Field to that later. Have you read that?
I haven't read that.
Okay, well, I won't ask you any questions about that. I'll save that for written submissions. It's not fair to ask you questions about it. So I just want to look at what one other inspector said about this, which is the inspector at Marden. We've been here already. It's called document CD 7.29.
Thank you. I have it, yeah.
And if we look at paragraph 49, so this is the section talking about BNV, the written ministerial statement, Bramley Solar Farm. And paragraph 49 says the council accepts that the borough in general has a higher than average proportion of BNV, and I accept it would be difficult to find an alternative site which is entirely made up of lesser quality land. Criticisms was levied at the lack of detailed land quality assessment studies, but requiring such extensive, time-consuming and no doubt expensive analysis, even if permission was granted by the landowner, would be a disproportionate and unreasonable burden on prospective developers. In light of the climate change emergency and binding net zero targets, alongside the fact that this land has not been identified for its high environmental value, I'm in no doubt that it's demonstrated that use of agricultural land is justified here. You see that?
I see that, but that's in the context that the inspector has accepted it would be difficult to find an alternative site. Obviously, we're asking the inspector to reach a different conclusion on this case.
And you agree here, as in that case, that the borough in general has a higher than national
I don't know
proportion of BNB.
Which paragraphs, if you take me to them.
So the start of the paragraph we're just looking at, start of the inspector's consideration there is that the borough in general has a higher than national average proportion of BNB, and you accept that the same applies in the
so something higher than 42%. It looks like 47% of that appeal site was.
And here we're 57% BNB.
No, I'm talking about the appeal site.
I'm talking about the proportion of the borough that's BNB.
Yeah, I know. I'm just noting. I'm just having a look. See, okay, I see it. Remaining 50% is definitely not. Sorry, where does it say, does it give a figure for the percentage of all bump?
I don't know. I don't think it does necessarily.
Okay, but it's
just says
higher
in
than that's an
that
average. No reason to doubt that, yeah.
And so the final methodology point you raise is as to the size of the site being searched for. And that's because with some sub areas of the grade 4, you say there's a 40 hectare site, so a site almost a third smaller than this scheme that could potentially represent an alternative. Right.
Yeah.
And a 40 hectare site would by necessity mean a smaller solar farm.
Yeah.
And it would be a project that would no longer utilise the full 49.9 megawatt grid connection. It would be smaller.
Presumably, yes, yeah.
And so the result would be the grid connection offer was not deployed to its full extent.
Yes.
And we've agreed already that grid capacity should be.
Well, actually, sorry, the result would be you couldn't use it because you've already got your grid connection at Burcot solar farm. So you'd have to seek a fresh connection.
Yeah.
Wouldn't you? These aren't really searches for alternatives, they're searches for additional sites.
Yes, exactly. But a smaller site where it's able to use this grid connection wouldn't be an efficient use of that grid connection because some of it wouldn't be deployed.
Well, you've already told me it couldn't
Yeah.
use that connection. A fresh connection would be sought, presumably, to accord to the size of the site that was being considered.
And I briefly want to turn to look at the assessment carried out within the triple SI, SSR. Start by considering what we have at the appeal site. So it's flood zone 1.
Yes.
And there's no footpath running through or adjacent to the site.
Well, depends on your definition of adjacent, but there's one that runs relatively close by to the south of the site, but it's not directly adjacent there.
There's no heritage objection.
No, there's a degree of heritage harm, but there's no objection. The heritage balance is passed.
There's relatively flat topography.
Yes.
And while it's greenbelt, it's agreed the site doesn't make a strong contribution to the greenbelt purposes.
Correct, other than the sea.
Other than sea. And even on the council's case, there's compliant with every policy in the plan other than DES 7.
Yes.
And as to the other potential areas for development, we agreed yesterday there's no brownfield or urban previously developed sites available to accommodate this scheme in South Oxfordshire, or the Vale of Whitehorse.
Yes, we agreed that, yeah.
So we're by necessity looking at greenfield agricultural land. And you also accept in your proof that within the 8-kilometre search area, if that's right, there's no non-greenbelt sites that could accommodate the proposal.
That's correct, yes.
So if we take up the site selection report, please.
Yeah.
And if we go to page 39. Sorry, that's probably not very helpful. The PDF, the appendix 5, which is the map of.
Yeah, no, you're right. It is 49. Yeah.
You can see there that most of the area is grade 1, 2, or 3. So it's the green, the brown, or the red.
So yeah, what did we say overall? Mr. Field says 57% is BMB
of the whole district.
Of the whole.
Yeah. And the potential grade 4 areas are in blue. Is that right?
Yes.
And so the appellant's gone through those grade 4 areas within this document and looked at whether they might be suitable for a solar farm.
Not completely. They have in part, but there are a number of areas where I say that effectively the search is inadequate or hasn't been explained.
But that's the approach of this document, to take each of those areas and just to make the appellant's comment on whether it's suitable or not for a solar farm.
Yeah. So my understanding is that the site selection report from November 2023 considered 23 different sites. But didn't consider any of these sites. All the sites that were considered were EMV on the 2023 report. The council queried the site selection process. This document was produced, and these additional 8 areas were then considered by the appellant.
I'm not sure that's exactly right, because some of the sites that were considered in the original report are in this site as well. But we'll get there in due course. This is the site selection report that the appellant has put before this inquiry. So this is the one we're going to look at. So I'm going to ask you some very specific questions about this. The inspector has heard all of your detailed criticisms in examination in chief yesterday.
Well, it's in chief, so it's not in full, but yes, a summary.
Yeah, but so if we can try to sort of focus on the questions that I'm asking, and if you want to expand, of course, you can. To the first, you don't raise in your proof any issue with what the appellant said about areas 3 and 4. So we're going to start with area 5. And if we go up to 4.26, SSR,
Sorry, 4.26.
which starts talking about area 5. And there's an extract from the constraints plan overleaf.
Yeah, I have that.
So this report points to a number of constraints with area 5. There's a triple SI, listed buildings at Horse Park, the sports park, and the Oxford Country Park. So that's what it says about this area. Your point, I think, is that a smaller 40-hectare site could be available within the broader area 5.
A 60-hectare site.
Well, so where is that in your
figure 5, page 35?
Let's take up your proof. There's a 60-hectare area, so you say at 5.54, the appellant confirmed a 100-acre site was required for a viable solar farm.
Yes, I didn't pick that out of the air. That was the appellant's evidence in the previous site selection survey or study, was that a minimum size of site was 100 acres. So anything above 100 acres could be possible.
And so that was what the evidence was then about the minimum size of a viable site. And the appellant's evidence here is that to deploy the full grid connection, you'd need a site of this size.
But that's irrelevant. You can't. You've already agreed. You can't deploy the grid connection on an alternative site.
Well, then why are we looking at this at all?
Well, that's the problem here, because the problem is there are additional. You're looking at additional sites. Your grid connection was secured.
Yeah.
A deal was done with a Burcot solar farm.
Yeah.
You're moving forward with that. And this is a retrospective exercise taking place after that effectively you've decided that you're going to develop Burcot solar farm.
Well,
so that is
the site selection exercise was undertaken before any of that was carried out, obviously, because this site was chosen, and we've agreed that a number of factors go into that site selection exercise. You are correct that there isn't
the chronology.
There isn't.
Sorry, that's not the chronology.
Well, at the start, obviously, a site was chosen at some point.
So where's the evidence to show the site was chosen before Burcot Solar Farm the deal was done with Burcot Solar Farm? The limited company was established in 2021. So by then, clearly there was a deal in place.
Of course, at some point, this site had to be chosen. There was a site selection exercise at some point.
Yes, it was done after that site was chosen. That's the problem. It was done in 2022. It was refreshed in 2023. And then another document now has appeared in 2024, all of which post-date a connection agreement that deal under the formation of the SPV at Burcot.
And that's the point exactly, that no other site now is realistically able to come forward to use this connection. That's the appellant's point.
Well, you're looking for additional sites.
Yes.
The appellant was looking for additional sites in the 2022 study, because they say we've written to lots of different sites, all of which involve BMV land. But that's the nature of developing. That's what solar farm providers do. They write to lots of people who own land to try and find sites. They weren't looking for alternatives, they were looking for additional sites.
And the point exactly, and I think we're in agreement, and part of the conclusion of that is that the reason this site selection exercise is to prove the benefit that Mr. Cousin gives to the weight to the lack of alternatives in this case.
Well, it certainly doesn't address DES 7.
Well, all DES 7 says is we've gone through that already, explore reasonable alternatives, and we've agreed that that's exactly what this site selection report does. It looks at alternative areas that are not BMV. So we're on area 5 here. You accepted in chief that the smaller site you've identified might be even smaller than that because of the slope in Mr. Cusson's rebuttal in the northern part.
Yeah, I've been to the site and walked the footpath, and there's a small area in the northern tip. So the bit that kind of is stuck outside to the north of the main body of the site. The parts of that site are up to about 5% at their steepest.
Yeah. And so area 6.
I don't accept that necessarily means you can't develop them. What I said was that that's kind of the upper limits of what the solar farm provider might consider.
I mean, you're aware that the slope has 2 issues. One is about efficiency and the physical placement of the panels. The other's about visibility and vicinity to residential properties and footpaths. And the slope can have an impact in terms of visual, can't it?
Yes.
Yeah. So area 6, I think your gripe here is really one about methodology, because you don't accept the 8-kilometre limit to the search area. But nonetheless, if we look up the constraints plan on page 37, and I think you accepted that in chief as well, there's a number of constraints on area 6, not least the 2 triple SIs, Holton and Waterperry Wood, and a flood zone.
Yes.
Yeah. Area 7, you've identified again a smaller area in your proof that you say might be suitable to the south of the Wheatley bypass.
Yeah.
You accept that there's a public right of way running through the centre of that site.
I've walked it, yes.
Yeah. It's also next to the residential area of Wheatley.
It is, but it's quite visually distinct from it.
And you also have seen in Mr. Cusson's rebuttal that part of that land is steeply graded in the area of Castle Hill Farms.
Yeah, so as I said in my chief, it's the sort of the northwestern area. The land rises more steeply so, and also did accept the point that was made that part of that kind of northwestern tip has a north-facing slope, so it's sloping down towards Wheatley, so I accept that wouldn't be suitable. So what I was saying in my chief was that essentially if you took the lower part of the site that's closer to the river, and then you would reduce the size of the site significantly, but it is a 92 hectare site, so I still think you could achieve around the size of site that the appeal site you guys is.
So the next area is area 8. So if we look at page 41, which is where the areas are mapped, just to remind ourselves where that is.
Yeah.
So that's the sort of relatively smaller area to the southwest. And as you, I think, accept in your proof, the western part of this area is in a flood zone.
Yes.
And to the east, there's already a planning application for a solar farm.
Yes.
And there's also, if we look up to the constraints map, a scheduled ancient monument in that area, isn't there?
Yeah, let me just refresh this.
It's that sort of dark pink bit above Lower Radley.
I'm just going to go to the yeah, I see that. Yeah.
So area 9, so more in the centre of the plan.
Yeah.
So we can agree that there's a conservation area and listed buildings within that at Toots Baldon.
That's correct. Yeah.
And you say in your proof there's been no analysis of the significance and setting of those particular listed buildings, or the contribution of particular fields to their significance. But a detailed assessment of individual listed buildings be beyond the scope of a high-level site search assessment.
So it's a high-level site search.
Yeah.
Okay. Well, it's not the most compelling evidence, and it shouldn't be a high-level document. It should be consider this site as, and in fact, part of this site 9 is labelled being possibly developable, and then there's a statement as to what happens to that. So I don't know which fields that related to or which it didn't. They're honest, but of course at the appeal site, we're next to a grade 1 registered parking garden. But that site is proposed to be developed. So it's not necessarily the case, in my view, that the setting of those listed buildings into Borden prohibits development of a solar farm on those fields. And I've identified an area of 227 hectares. Well,
you don't say that when an appellant is conducting, I mean, there's no methodology to start with, so it's a matter of judgment. We've agreed it has to be reasonable and proportionate. When an appellant is conducting a search in an 8-kilometre radius area, that they should be carrying out specific heritage assessments of individual listed buildings. You can see the number of listed buildings in that area. That would be entirely disproportionate.
The site selection report is produced by a planning consultancy who have a heritage arm, and it's a fundamental, one of the key parameters in your site search, your 13 parameters, one of them is to consider heritage. I mean, if you're not going to even consider whether or not there's an impact, why is it even in there as a parameter? Because you're just going to ignore it and say the site's suitable.
Well, it's entirely disproportionate to think that someone's going to, in the same way as that, to think that it's reasonable to expect developers to dig up other people's sites to test the soil, to conduct individual assessments of individual listed buildings across an 8-kilometre search area.
Well, you would look at obviously the areas from which you can, what I'm trying to understand what the setting of those listed buildings comprises, understand where they might be visible from. It would, if a planner or a heritage consultant visited that area to look at that site, they could, in my view, reach some sort of informed judgment as to whether or not it was an appropriate site. It might need more detailed work. I accept that, but it's not, you can't, in my view, simply say, well, it's too difficult because there's, 4 or more listed buildings, which are at the northern part of that village. Therefore, we can't develop an area of over 200 hectares, much of which is well outside of Borden.
And you're also aware that there's an extensive footpath and public right-of-way network running through that area 9 around there.
If those are the green, I'm aware there are public footpaths.
And there's also some areas of flood zone 2 and 3 in area 9.
So I've excluded those from the polygon that I've drawn in my figure 8, accepting that your internal methodology that you wouldn't want to develop in the floodplain, although it is a water compatible form of development, as you know.
And are you aware that a large part of area 9 is owned by Queen's College, who are strategic landowners, and they have been contacted and didn't express an interest in progressing this?
Well, I'm not aware because I haven't seen any evidence.
And you will be aware that part of the consented Nineveh solar farm is also within that area 9 to the west.
Yes.
And I assume you're also aware that to the north of this area 9, there's also a strategic housing allocation.
Yes.
Yeah. And obviously this farm can't go where that strategic housing allocation.
No, and I'm not including the allocated site within my polygon.
So area 10, finally. So if we go to the page 26, which is the extract of the constraints plan with respect to this area.
Yeah.
So you can see there's an extensive public right-of-way network and flood zones again. And the site selection report identified there 2 sub-areas that it said might be suitable.
Yeah.
And the land to the south is not available for development. And that's identified in the original PPS report as meaning the landowner was contacted and didn't give any response.
Well, yeah, I don't know because you're telling us not to have any regard to PPS.
Well, it says here.
You say this completely supersedes it
at
the start of this document. So are you relying on it or not? You can't have it both ways.
Well, it says here within this document, the PPS document confirms this site was not available. 4.3.
Right, okay.
And as to the sort of smaller area to the top, you can see there that there's actually 2 footpaths running through it.
Yes, but solar farms are developed. I've seen them developed where there's footpaths going through the sites. It's not a barrier necessarily. It's just one parameter to consider in the overall mix, isn't it?
It is a parameter to consider in the overall mix. Thank you. So in that context, just taking a step back, we can agree that these provisional grade 4 areas are potentially subject to constraints that could impact their suitability for a solar farm.
Some of them are, yes. Some of them I think are potentially suitable.
Potentially suitable, but within all of them, there's constraints that could impact their suitability.
Well, not that have been identified, but I'm looking at 5, 7, so I say 8, 9, 10. I say the other ones I agree that there are, but I mean, there's always going to be some form of constraint if you're looking at any alternative. There's constraints on the appeal side. If you ruled every site out where there was constraint, you would doubtless ruled out the appeal side as well.
So I'm not going to go back through all of them. We've talked about the constraints in each of these areas, but I think the point you say fairly accept that there's going to be some constraints on any of these alternatives.
On some of those.
Well, you just said there's going to be some form of constraint on any alternative site.
Well, I'm saying that on some of those sites, the constraints, you've done the analysis, Pump's done the analysis, come forward and explained why some sites are not suitable. That analysis is a moving feast and has changed several times, but taking that into account, I'm not convinced that that analysis justifies removing the sites that I've listed in my proof. The other sites, I agree, yes, they're not suitable alternatives.
So then I want to address the point that even if you're right and that compelling evidence is required to demonstrate the use of BMP, you accept, don't you, that there are means of demonstrating compelling evidence without considering alternatives at all?
No, not necessarily. Give me a scenario. What it says, the PPG wouldn't say what it says. It would be irrelevant to consider whether it was BMP. If the national need for renewable energy immediately outweighed any concerns on loss of BMP, the policy would say that. That's not how national or local policy in this case works.
Well, the PPG and the written ministerial statement are from 2015. The government has announced they're out of date, and that's where the compelling evidence test comes from. And that's exactly what a number of other inspectors have considered to be the case. And if we just take up the core document 7.23.
Well, they've said they're going to clarify the PPG to bring it into line with the NVP. They did. They said they're going to clarify. They didn't say what they're going to do. We don't know which parts they're going to change, how they're going to change it. We have to, this appeal has to be determined on the basis of the current policy position.
So can you please take up
7.23. I have it, yeah.
166. Do you have that?
Yeah, I have it, yeah.
So the inspected evidence, I recognise the 2015 WMS requires the most compelling evidence. However, this must be read in light of more up-to-date events. This includes Parliament's declaration that there's a climate change emergency, the NPPF support for renewables, all these other policy statements. And it must also be viewed against the increasing imperative to tackle climate change and to meet legally binding net zero targets. Together with specific considerations in these cases, I consider these factors provide the most compelling evidence to justify the use of BMP. You see that?
The key bit is together with the specific considerations in this case.
Well,
we don't have those specific considerations before us.
You say that's the key bit. The key bit is clearly all those other considerations that the inspector thinks are relevant. We're just going to look at two others. So that was Inspector Hayward. Can we now look at Inspector Parker's decision in Poplar Farm, CD 7.43, paragraph 45.
I have it, yeah.
Yeah, so the compelling evidence also exists in the wider context of renewable energy creation, the overall trend towards net zero, tackling climate change. Since 2015, the government's published a plethora of documents outlining the urgency of moving towards low carbon. This has been reiterated in the January 24 written ministerial statement. and so on. You see that there.
I see that, yeah.
Finally, if we take up the decision of Inspector Major at Marden, which is full document CD 7.29, I think we've been there already.
Yeah, you're right.
Paragraph 51. It's accepted by the council that provision of renewables carries substantial weight when taken alongside the imperative to ramp up the provision of electricity from solar farms and the urgent need to address climate change. I'm satisfied there's ample compelling evidence for use of this land, including the proportion of BNB for the proposed development. You see that there?
I see that, yeah.
So next I want to look at the planning balance. So I want to start by understanding your scale for weighing benefits and harms. So does it go limited, moderate, significant, substantial? I think
Yes, that's
yeah.
correct, yeah.
And so in terms of adverse impacts, while in your proof you had substantial weight to the green belt, that now comes out.
Yes.
And so you've already said you give significant weight to the harm to DES 7 and BNB.
Yeah.
And in your proof, there's two other additional sets of environmental impacts that we also agree should be afforded some harm in the planning balance. There's disagreement on the BNB, but agreement that there should be harm to both landscape and
yes.
heritage. So first heritage, and I think there's full common ground here between us, because there's going to be some low-level harm to the RPG and conservation area, but it's agreed that would be outweighed by the public benefits.
Correct, yes.
And on that basis, it's also common ground, as set out in the main statement of common ground, that there should be limited adverse weight to heritage in the balance.
Yes.
So the second area where we agree there's some adverse weight is to landscape. And just to think about the weight to give to that harm. We can agree, can't we, that large solar farms today are invariably found in rural areas?
Typically so, yes.
Yeah. And if they're going to be in the countryside, there will by necessity be some level of inevitable adverse landscape impact.
I'd say ordinarily, yes, they're very large schemes, albeit they're relatively low slung, to use Mr. Cook's phraseology.
And that's part of achieving net zero. There's going to be landscape impacts because solar farms have to be developed and they're going to be in the countryside.
There's going to be more solar farms, yes.
And as with heritage, the council considers the scheme complies with the relevant landscape and heritage landscape policies in the plan.
Correct, yes.
And that's because while there is some inevitable harm, it's not at an unacceptable level in this case.
Yes.
And we've just agreed already, you're aware there's no public rights of way crossing this solar farm.
Yes, there's one nearby, but not crossing it, no.
And you're also aware that the appeal site is undesignated countryside, and it's agreed in the landscape statement of common ground that it's not a valued landscape for the purposes of the
correct,
yeah. And Mr. Cusson concludes on the basis of Mr. Cook's analysis that limited weight should be ascribed to the landscape impacts. Is that something you can now agree, given the council's withdrawn Mr. Randall's proof?
Yes.
Before turning to the benefits, I just want to turn to that very important document in determining this application, which is the local plan.
Mm-hmm.
And as you explained in your evidence yesterday, the only policy with which the council now contends there is a conflict with is DES 7.
Yes.
And even in terms of DES 7, you only say there's conflict with 1 out of 8 criteria there.
Yes.
And if we just go within the local plan to policy DES 9, please. So that's page 206.
Yes, sorry, 206.
I think so.
Yeah, I think that sounds right. Yeah.
And just before we go there, it's right, isn't it, that when we look at whether a proposal accords or conflicts with the development plan, what we've got to do is read the development plan as a whole.
Correct.
And we can agree, can't we, that conflict with one policy, or indeed one part of one policy, need not mean conflict with the plans.
Not necessarily.
Yeah. And that's the Corbett and Cornwall Council case. And here, when we're thinking about the plan as a whole, the primary local plan policy in relation to renewable energy proposals is DES 9.
Well, DES 9, DES 7.
Well, the
Strat
renewables
6.
policy is DES 9, isn't it?
I'm just talking about the ones that are the agreed most important policies in the same common ground.
I'm talking about, in general, the primary policy for renewable energy, all forms of renewable energy in this plan is policy DES 9.
Not just DES 9, but yes, DES 9 is a most important policy, but there are other policies which are, for the reasons we've already discussed, are relevant in terms of considering the acceptability of the proposal.
Agreed, but DES 9 is the only policy that specifically deals with criteria for assessing renewable schemes. It's the only one that addresses renewables specifically.
Specifically, yes.
Yeah. And it's a positive policy that encourages schemes for renewable and low carbon energy generation, isn't it?
It does, and there's been lots of approvals.
And it provides specific support for schemes that don't cause significant adverse effects to 5 criteria.
Yeah.
And it's now common ground, as you've explained a few times, that the appeal scheme complies with those criteria.
Correct.
And given that the appeal scheme complies with this key policy, it's reasonable for Mr. Cusson to conclude that it complies with the development plan, read when it must be as a whole.
Well, I don't agree that. That's not my evidence. That's Mr. Cusson's evidence.
Well, no, your case is that it just complies with the renewables policy, it complies with the heritage, it complies with landscape, it complies with everything except one criterion of one policy that doesn't refer to renewables at all. And you say on that basis, still the scheme conflicts with the development plan, read as a whole. That's
when read as a whole, yes, that is my position.
And we can make submissions about that. I have your answer there. I wonder whether you want to take a break at some point. I don't think. I'm probably about 2/3 of the way through this morning.
Right.
So maybe another half an hour-ish.
If you've got about another half an hour, I think maybe just go on.
Keep going.
Yeah,
Maybe
if
45 minutes.
Yeah,
you're
absolutely
right.
fine.
Yeah.
Absolutely fine, yeah.
I wouldn't want to go beyond about 11:30.
Yeah. Okay, I think we should be all right. So I want to turn then to the benefits of this scheme.
Yeah.
So the first benefit, we've agreed there's a huge need for rapid delivery of more clean energy to decarbonise the UK's electricity supply.
We have.
And we saw the new Clean Power 2030 documents that said there's a once in a generation shift in the pace of delivery that's required.
Yes.
And that unprecedented volumes of clean energy infrastructure are needed.
Yes.
And we've also agreed yesterday that the greater the need, the greater the benefit, the greater the weight of the benefit. And on that basis, Mr. Cusson, like a number of other inspectors and the Secretary of State, has afforded the clean energy 49.9 megawatts here substantial weight with respect to its contribution to those climate targets. And we know from yesterday, you say significant weight because of the new NPPF, and I don't need to go through that again. We've discussed the differences in views on that. So the second benefit Mr. Cusson goes through in his proof relates to the declaration of a climate change emergency by this local authority. And you agree, don't you, that South Oxfordshire has declared a climate emergency?
It has, yes.
And I think we also touched on this yesterday. It's a council that itself has a stated ambition to be carbon neutral by 2030.
Right.
And a national climate emergency was declared by the UK Parliament in 2019.
Yes.
And it's common ground between us that those climate emergency declarations are material considerations with respect to this appeal.
Yes.
And there are obviously material considerations weighing in favour of the appeal.
Yes.
And the solar farm would represent a significant contribution towards addressing both climate emergency declarations.
Well, in isolation, no. In the same way that the loss of agricultural land looked at in isolation wouldn't mean that make a huge impact nationally in terms of farming enterprise.
I just want to double check. My note is that that was agreed as part of the on ground. Yeah, so if we take up the main statement of common ground, paragraph 7.46.
I have it, yeah.
So see, the solar farm element offers an opportunity to secure a renewable scheme at 49.9 megawatts. This would be a significant contribution towards addressing the climate emergency declaration that the council has declared. You see that there?
Yeah, but that's a local
Yeah.
climate emergency
Okay.
declaration. You were talking about the national.
Oh, sorry. So you're happy to accept it? It's a significant contribution.
Yeah, it's a significant
to the local.
contribution at a local level.
Understood. And that's a benefit that weighs in favour of this scheme, isn't it?
That's agreed. It's in 7.47 goes through the council's and the appellant's position on all of the material considerations.
So what weight do you give that as a benefit?
Significant.
And that's a separate benefit to the general renewable energy generation to meet national targets.
No, I don't think it's a separate benefit. I think it's all related to the same benefit. Mr. Cousin takes his proof doesn't seem to align with the statement of common ground in terms of positions as to what the benefits are and weights to necessarily forward to them. Looking at the statement of common ground, provision of renewable energy is down as a single benefit. I mean, I think it's like slicing if you have a cake and you can slice it into 8 pieces,
yeah,
or you can slice it into 4, you still have the same amount of cake. So I think it, I don't think it makes much difference, but he's addressed it in a slightly different way in arguing the significant weight his proof should be given to other benefits, but that isn't consistent with what's in the statement of common ground.
Well, if we also have a look at how other inspectors have treated local climate declarations, if we just take up the Southlands appeal, and I think maybe keep this one open, which is called document 7.40. And the point about the climate emergency declaration is that not all local authorities have it, and it's about an emergency, so it's something short-term and urgent. And this scheme could contribute in a very rapid way to meeting that, couldn't it? In a way that other schemes with longer grid connections wouldn't be able to.
Yes, that's fair.
Yeah. So if we go to paragraph 99 of this appeal, this was also a local authority that had declared a climate and ecological emergency. I think this local authority had declared an ecological emergency as well.
That's correct,
That's
yeah.
correct, yeah. So the inspector says Chelmsford declared climate emergency. The solar farm SPD recognises solar complete targets. Rochford declared a climate emergency, and the contribution of the development towards mitigating the climate emergencies also attracts significant weight as agreed between the parties. And there, that's in addition to the weight that the inspector's already given to renewable energy generation.
Yeah, I see that.
Yeah. But so would you give any weight at all? Some weight?
It's all part of one weight that I give to the. It's all about the production of renewable energy. That's the benefit. That contributes towards the climate emergency. Of course, it does. And the overall need. It's all part of the same benefit. But it's that how many slices you want. It's the same cake.
You accept, don't you, that when you, for example, build a housing scheme, that could have benefits in terms of the same houses could have benefits in economic terms, in terms of meeting housing targets. The same thing can have multiple benefits.
I've taken it into account. It's how you package it up. That's all this is. It's a presentation point.
So next I want to talk about, we've talked about solar, clean energy generation.
Yeah.
And now I want to talk a bit about batteries. And I think there's more common ground between us here. You accept, don't you, that in addition to solar energy, this scheme also comprises a co-located battery storage
Yes.
facility of 49.9 megawatts.
Yeah.
Yeah. And we agreed yesterday that beyond the need for new energy generation to meet net zero, there's also a stark need for new battery storage.
Yes.
Yeah. And as set out in all the documents, we can go there. Battery storage is itself crucial to meeting net zero, to enable the power generated by intermittent renewables to be deployed consistently.
Yes, it's a facility to obviously regulate the way in which the electricity is released to the grid. So when there's high demand, you can release more. So it's yes.
And you do accept that the battery storage element of this scheme is a separate benefit to the solar generation.
Well, I'm treating it as one benefit effectively, but we do in the statement of common ground accept its benefits. So there's no question that we're not taking into account the BES as a benefit of this scheme, as opposed to a scheme which didn't have a BES. There's more benefit here, yes.
So it's a separate benefit that must attract weight by itself in the tank.
Depends how you want to package it up, I think, ultimately. But I think we're talking about the same thing. I'm giving weight to the fact there's a BES. If there wasn't a BES, there would be less weight given.
So there's significant weight to the solar. There's also separately has to be weight to the BES. It's an entirely separate part of the scheme that meets a different needs.
Well, it regulates how the electricity is put back into the grid. So it's all part of the same operation.
Well, you can have a solar farm without a BES, and you can have a BES without a solar farm.
You can. My point is, I've taken it into account. If you want to describe it as a separate benefit, as opposed to the benefit of producing renewable energy, then you can do that. I don't have a problem with that. It's the same weight that I'm taking it into account in my weighting.
So you've given one set of significant weight to renewable energy. What I'm saying is there has to be, you have to accept that there's a separate weight to battery storage here. It's an entirely separate element of the scheme.
I know, I've taken it into account. It's all part and parcel of the generation of renewable energy and the distribution of it to the grid.
Well, so it's not generation of energy, is it? The battery storage. What it does is stores
it
energy
regulates
from the grid.
the release of energy back to the grid.
It
makes so I agree it's a benefit. I'm not saying it's not a benefit. I have taken it into account.
So how much weight do you give the solar farm by itself?
I give significant weight to the benefit.
Of the
I'm treating it as a
storage.
whole. So yes, but
Okay,
the benefit's
I'm
bigger.
asking you to consider them separately for a moment. So if it's standing by itself, a 49.9 megawatt solar farm, you would give that significant weight.
I would give significant weight to it, but it would have less weight if it was a solar farm without a BES.
I understand, but your scale only has 4 levels on it.
Mm-hmm.
So the solar farm is significant weight standing by itself.
Yes, if you want to package it up in that way, it makes no difference.
I understand, but I have to go through this because they are separate parts of the scheme. So solar farm by itself is significant weight.
Yeah.
And the battery by itself, how much weight would that get?
So significant for the battery, and if you go to 7, if you still got the statement of common ground open, 7.46, you'll see there we agree it contributes additional weight in favour of the overall proposal arising from renewable energy benefits.
Okay, so the solar farm by itself is significant weight and the battery by itself is significant weight. Thank you.
It's one proposal.
It's one proposal.
Yes.
Yes. And because you're aware, I'm sure that there's appeals where schemes comprising standalone batteries have been granted consent, even in the Greenbelt, because of the substantial weight that's been given to batteries.
Yeah, the Walsall decision.
Yeah.
Yeah.
And we have that Southlands appeal open, so I think the inspector there agreed with you. If we look at how she treated the batteries, paragraph 100.
Yeah.
So she agreed that the proposed development would include BES, which would ensure energy generated during times of low demand can be released back to the grid. It's supported by the energy security strategy, and the parties agree, and I concur, that significant weight in favour of the scheme is derived from its co-location with the BES facility.
Yeah.
Yeah.
I see that. Yeah.
So, and that's something that's not specifically referenced in your proof, but it is there in the statement of common ground.
It's been taken into account.
So the fourth benefit of this scheme that Mr. Cusson refers to is the contribution to meeting domestic energy insecurity. And can you accept that the energy security crisis is something that can and does exist quite separately to the climate crisis?
Yes, if you go to page 21, the statement of common ground,
yeah,
under social, you'll see addressing UK energy security, significant positive, both of the parties agree significant positive weight to it.
So again, that's significant positive weight in the planning balance.
Nothing between us.
Scheme. So next, I want to look at best available technology and good design. So I don't think this is something you give any weight to.
No.
But can we agree, as a matter of fact, that what is proposed here is the use of bifacial panels, which can increase continual electrical production compared to traditional panels because they allow for greater efficiency and light absorption?
Yes, and that's reflected in the overall level of energy that we generate.
And there's no requirement for solar developers to use that technology at present.
No, I don't know.
And it effectively increases the yield for the land taken, so it represents the best use of land.
Yeah, and then it makes economic sense, doesn't it? You can generate more electricity on a smaller piece of land. So, yes.
And that design of this scheme, the efficient use of land, it is a separate benefit, isn't it?
No, it's not. It's all factored into the overall level of energy that would be produced. You're using efficient panels. You're producing more electricity. I'm giving weight to the benefit of the additional electricity that you're producing. It's not a separate benefit.
Well, you're the same amount of electricity, but using less land than you'd otherwise require.
It's a matter for the developer.
Ultimately. Well, can we take up one other appeal here, which is the Honolulu Road appeal? This is both an inspector decision and the Secretary of State.
Okay. What's the
call document 7.41?
Oh, yeah.
And if you go there to paragraph 186 of the inspector's decision, we can flip back. It's paragraph 30 of the Secretary of State's decision that agrees with what the inspector says there.
Right, I have 186, yeah.
So can you see there that the Secretary of State and the inspector considered that the use of efficient technology enabling efficient use of land would be accorded moderate weight in favour of the solar farm proposal there?
Apologies, 186, making the most efficient and effective use of land as central tenet of land use plan. Are we in the same paragraph?
Yeah. In this respect, the proposal's use of efficient technology is a positive factor in favour of the proposal. It's likely to require less land than fixed panel arrays, while also producing more energy overall. As such, this is there the inspector says substantial weight. Mr. Cousins has been a bit more moderate and said moderate weight. The inspector could take the same approach here. She could say moderate. She could say, like the inspector and Secretary of State, they're substantial in favour of the design.
Yeah, it's obviously a matter for the inspector to determine whether, and if there is, what weight should be afforded to it. My point is essentially that if you're producing more electricity because you're using efficient panels, then you're getting more benefit there. If you're using less BMV land because your land take is lower, you're causing less harm there. It's been taken into account in my evidence. That's my point.
So the next area is economic benefits, and you accept, don't you, that economic benefits would arise? The difference between you and Mr. Cusson is on the weight to give them. And given there's not a huge difference between you, you say limited, Mr. Cusson says moderate. I don't propose to take up a lot of time with this. you don't dispute factually that the proposal would represent a total build cost of £52 million.
No, I don't.
And I don't think this is touched on in your proof, but it would also bring about job creation, wouldn't it?
Mhm.
And Mr. Cusson has outlined that there would be jobs in the construction, operation and decommissioning phases, and mostly they'd be in the construction phase, which would involve 60 to 80 direct jobs.
Yes.
You're aware of that?
Yeah.
And it would also create business opportunities for suppliers and those involved in the grid connection, transport, logistics, and opportunities for a number of different parts of the supply chain.
Correct.
Yeah. And given the scale of that investment, Mr. Cusson says moderate weight. You still disagree, despite what he's saying.
Yeah, I say it's a positive one.
The next benefit is the available point of connection, and this is another one where it's agreed it's a benefit, but you only give it limited weight, and Mr. Cusson gives it far more weight than that.
Yeah.
And given we've spent quite so long on the site selection report, I don't propose to go through the different conclusions you reach about that. In particular, we've also agreed that grid connections are limited, there are serious connection delays, and that grid capacity should be used where it's available.
Yes.
Yeah. So I don't propose to go through that again. Mr. Cusson can explain later why he thinks significant is more appropriate than.
But he said moderate.
Does he? Well,
Yeah.
He could explain that.
Yeah. In the
Moderate
statement
weight.
of common ground, page 24.
Well, moderate.
Yeah.
We'll get Mr. Cusson to talk about that. And similarly, the lack of alternative sites. We've agreed if the point of connection is the right starting point, 8 kilometres is the right radius, there's no non-greenbelt sites available.
If those points are accepted,
Yeah.
yes.
So in greenbelt terms, quite apart from the BMV issue, the alternative site assessment found no sequentially better site.
In terms of the green belt,
Yeah.
no. Of course, it only included a very small sliver of land at the edge of the radius.
And while there are no non-greenbelt sites are available, we've agreed that this scheme uses the less strategically important grey belt band.
Yes, I mean, it's all change, isn't it?
Yeah. And I, again, don't propose to go through the SSR in detail, but if the methodology of that is right and the inspector finds there aren't any preferable alternatives, that can be a benefit that weighs in favour of this scheme. I think we agreed that earlier.
We did, yeah.
And so the next benefit I want to look at is farm diversification. And you are aware that paragraph 88 of the MPPF states that planning policies and decisions should enable the development and diversification of agriculture and other land-based rural businesses.
Yes.
So that provides support for diversification of rural businesses.
Yes.
And there's actually a local plan policy in this regard as well, which is EMP10, which says the council will promote the sustainable development and diversification of agricultural businesses.
Yes.
And you're aware that this is a challenging time for farmers. They've got loss of subsidies. Yeah.
Yeah.
And increasingly volatile weather conditions, including climate change induced weather conditions.
Yes.
Yeah. There's also price fluctuations in grain and imports of fertilizers, all kinds of things that farmers are having to deal with at the moment that make it challenging. They've heard a lot about it in the press.
Yeah.
You'll have read from Mr. Field's proof that this is a family farm going back generations on this site.
Yeah.
And you'll have also seen that, as you point out from the original application agricultural report, the farm had been profitable in recent years, but that was relying on diversified income. It wasn't profitable just from the arable production itself.
Yes, I understand there's other economic activities taking place at the farm, which obviously contribute to the overall financial position.
And that report predicted that the farm could be making a loss by 2028. Do you remember that?
I don't remember.
Well, if we just maybe take it up very briefly, it's core document 1.15.
Too many. I've reached my limit of PDF. Shut a few down.
We're nearly there.
My computer says something. Oh, it's 115.
1.15.
Still not opening. Oh, it says it's damaged. I'll try and go in.
It was damaged on the council's website, but they fixed it. So the one I downloaded is also damaged, but it's now working.
Sounds like the explanation. I'll go back on the council's website and get it from there if it fits. Okay, I'm in.
So if we go to paragraph 3.6 within that. So that is on.
Yeah.
I've
got it, 24.
Yeah, so that what that explains is that it predicted that the existing arable shortfall could mean that the entire enterprise would be making a loss by 2028.
I see that. Yeah.
And just while we're here, the next section talks about diversification. Paragraph 4.1 there explains what diversification is in the agricultural context, and it says it can be regarded as the reallocation of some productive resources such as land capital, farm equipment and labour to other projects, particularly in richer countries to non-farming activities and enterprises.
So that's the appellant's definition of farm diversification.
Well, I don't think whoever wrote this report is involved in this appeal specifically, but it's been
produced for this report.
Yeah, but is there? I mean, that's a fair description of what diversification is.
I'll try and might help if I explain my position quite short. I'm I don't consider this to be farm diversification. There are economic benefits for the farm that would result from this development, and those are taken into account as economic benefits. But it would be on a long-term, my understanding is it would be on a long-term lease to the solar provider, who will obviously install all the kit, have control of the land over that period, and then produce the energy. And then obviously when the lease ends, it goes back to the farmer, or there's a new lease and there's more, new solar panels or whatever. But so I'm not saying there's no weight shouldn't be given to the benefit to the farmer, the economic benefits of the proposal. But I'm saying, strictly speaking, I don't consider it farm diversification.
I can't quite understand that, because I mean, farm diversification is exactly that: giving part of your land, giving some buildings over to another different type of enterprise. And very often it's on a lease. I mean, if you have like a farmer with lots of land, I do work for one who often, without planning permission, leases huge areas to car storage companies, and that he doesn't control the car storage operation, but that's diversification of a farm.
I understand what you're saying. I mean, I've got lots of clients who are farmers, and quite often they will control them. Normally, the Airbnb type arrangements, things like that, that would typically remain in the ownership and control of the farmer. This is a 40-year period. This is not a short-term lease for someone to store cars on land. This is a 40-year period. So I don't think it matters, because it doesn't go anywhere, because ultimately I'm giving weight to the benefit. I'm just calling it something different. I think that's.
So if we added this benefit into the economic benefits, can we agree it's moderate weight?
No, I've added it in already. I still
get
say
limited weight.
Yeah.
So you say that the 50 million of investment, the 60 to 80 construction jobs, and the benefit to keeping this agricultural farm effectively in business over 40 years altogether is only limited weight.
I'm saying limited weight, and it's typical that the panels will be imported. They're not produced down the road and then brought to the site, they will be imported in all likelihood.
And you'll have read in this.
That's the vast majority of the investment.
You'll have read in Mr. Field's proof that actually the business made a loss already for the first time in the last financial year due to the very poor returns from the extremely wet conditions.
So my understanding is the farm has been profitable. It's been going for six generations, I believe, already, and it's made a first loss last year. So that's in the short term, it's made loss 1 year. It's presumably made a profit for many years before then. So I accept, and as we've discussed, I mean, that goes towards the need to both have more renewable energy to actually address the climate emergency, but it also goes towards ensuring that land you've got enough to actually farm to produce produce that you need, in having regard to the fact that we will get more natural climatic kind of events that will reduce yields on occasions.
And as you just said, we've looked already at Ed Miliband's statement that says the threat to agricultural land is not solar farms, it's the climate emergency.
Yeah, we've seen that, but we've also seen that the NPPF still required recognising of the economic and other benefits, which principally are obviously crop production.
So finally, I want to look at the benefits to nature that this scheme would bring about.
Yeah.
And they're twofold. So first, there's the biodiversity net gain. And it's common ground that there would be a significant biodiversity net gain of 86.7% in habitat units and 184% for hedgerow units here.
Yes, that sounds right. Yeah, I'm just looking at the statement of common ground.
7.43, I think.
Yeah.
And we can agree that quantitatively, what's provided there is it's a very high number and it's well in excess of the government's 10% target.
I don't want to say it's a particularly high number for a solar farm. I've seen solar farms producing much bigger figures than this. It's high having regard to the 10% national requirement. Of course, yes, it's 8 times it.
Yeah, 8 times the national target. And we agree that the target doesn't apply to this scheme because it was submitted before BNG came into force.
Correct.
And you'll be aware that in addition to the climate crisis, this country is also facing a linked nature crisis with many species risking extinction.
Yes.
And you say solar farms often get high biodiversity net gain scores, but against the background of the decline in biodiversity, you'll have seen from Mr. Cusson's proof that inspectors have repeatedly given those high BNGs significant or even substantial weight.
I'm aware that there are instances where inspectors have done that. I'm also aware there's instances where the inspectors have given moderate or limited weight to BNG.
Well, Mr. Cusson has set out, I think, about 10 different cases where inspectors have given significant or substantial weight, including to BNGs of exactly the same size of this scheme. And just to give you the references, we can go there if you want. I've just picked out 4 where the BNG was very
I'm not
similar
disputing.
to here.
I'm not disputing that.
You haven't put in any evidence that to support your conclusion that moderate is more appropriate.
Well, that's my professional view, is that moderate is the appropriate weight to be afforded in this instance. Had you been doing a much higher figure, then it might have been higher, but so it's not.
It's
that's
8 times the statutory requirement, which doesn't even apply here. Other inspectors with exactly the same BNGs have repeatedly given it significant or substantial. You've provided no alternative for why it should be moderate. I really can't understand how you've reached that conclusion.
Well, that is my professional view.
It's just your view.
It's my professional judgment having regard to the evidence before the inquiry. I think moderate is a perfectly reasonable weight, and I see it commonly in appeal decisions all the time. I don't think I'm going out on a limb. Well, I don't know. We'll have to go through them. Take some time.
But Mr. Cusson has gone through them, taken the time, and listed about 10 plus where significant or substantial weight.
And he's laid out his professional view, which differs slightly from mine. But I'm saying moderate, and he's saying significant. We're not miles apart.
But you don't bring any evidence to the inquiry to support that. So finally, the other environmental benefits are the green infrastructure and the soil enhancements. And Mr. Cousins grouped these together and given them moderate positive weight.
They're not in the statement of common ground as a material consideration of the benefit of the scheme. They're all under biodiversity net gain by the books.
Well, you've seen what Mr. Cousins set out.
Yeah, but we've got a statement of common ground. If Mr. Cousins wants to go off and raise other points, then he shouldn't have agreed the statement of common ground. That's the position we've agreed that we're working to. Those are the benefits that were agreed, and we put our respective positions on the weighting of those.
I mean,
I should be able to rely on the statement of common ground.
You should, and I don't think he disagrees with what's set out there, but you will have seen and heard the evidence from Mr. Cook about the green infrastructure benefits, and you'll have seen also what Mr. Field put in his proof about the benefits to soil.
It's not a benefit that you specifically argued as a separate point in the agreed statement of common ground.
Well, we can ask Mr. Cusson to explain why he's given that weight in his proof in due course. But forgetting for a moment where and what is agreed, can I just ask you, do you think it's a benefit that there would be improvements to the soil and green infrastructure?
Well, yes, because part of the biodiversity net gain calculation is hedgerows. So it's 186% increase. So again, we're risking double counting, and it's again a question of how you want to frame these things. But yes, there will by necessity be green infrastructure to deliver the BNG. It's all one interrelated point in my mind. And
do you accept that the soil would have to see environmental benefits as well?
I don't think there's any evidence before us to suggest that definitively it will or it won't. On an actual question.
Well, there is it. We've gone through the evidence in both Mr. Field's proof and the soil report that was put before the inquiry.
Well, Mr. Field's proof deals with other examples, and I'm not contesting the fact that leaving the land fallow. I think we've agreed the fact that leaving the land fallow can improve the quality of the land, but there's nothing before the inquiry to say that in this instance some assessment has been done and that's been proven that will be the case. That will have to be judged after the fact, don't it?
Well, what that evidence shows is that when you leave soil fallow, it does have benefits.
Yeah, and I'm not contesting that it can do. I'm just saying there's no evidence to say definitively in this case that it will, but I'm not saying it won't either.
I mean, what it's saying is scientifically what happens if you leave the soil fallow is that there are benefits in terms of soil organic matter, soil organic carbon. Might use tens of thousands of samples to reach that conclusion. There's nothing to suggest this scheme is different to all other schemes.
No.
So is that an additional benefit we can weigh in the balance?
So we've got impact. Well, no, because again, we're saying I've got significant negative weight. You've got neutral weight. So that's impact on agricultural land is what we're talking about. So you've got
the benefit to the soil is what we're talking about.
Right. Well, again, we were talking about a benefit which is not listed as an agreed benefit within the statement of common ground.
I appreciate that. I'm now asking your professional opinion about whether that's an additional benefit that can weigh in favour of this scheme.
Well, it's something that I've taken into account. And I'm not disputing the fact that a slight benefit could arise in that regard. The opportunity cost, of course, is that you can't use the land for 40 years for what it's actually most valuable for. So the overall conclusion on the agricultural land is significant negative weight against the proposal because it's using the BMB.
So a slight benefit. So you disagree with Mr. Cusson that it's moderate?
Well, it's not in this table. So, but yes, if it happens, a slight benefit, yes, I think that's fair.
So I want to just understand. So can we just recap so I understand where we've reached on the benefits? So I think we've agreed. You say there's significant weight to renewable energy generation.
Yeah.
Moderate weight to BNG.
Yeah.
Significant weight to the battery storage element.
Yes, but I packaged it up together. You choose to split it, but yes.
Limited weight to the economic
Yeah.
benefits.
Yeah.
Slight weight to the soil improvements.
Yes.
Significant weight to energy security.
Yeah.
And limited weight to the grid connection.
Yeah.
And you haven't given any extra weight to best available technology, lack of alternatives, farm diversification, or the climate emergency.
Well, the farm diversification points I've explained.
Says part of your economic benefits. And against that, we've got significant weight to BMV.
So against that, significant weight to BMV.
And we've agreed limited weight to heritage.
Well, great weight, but a limited amount.
In the balance. And limited weight to landscape.
Yes.
I'm sorry, Mr. Reynolds, but even on your own balance, I really struggle to see how that comes out as a conclusion in favour of a refusal of this scheme. The benefits include a number of significant benefits, moderate benefits, limited benefits, set only against significant to BMV, and 2 sets of limited environmental harms. Even on your own case, I just can't see how you're possibly saying this should be refused.
Well, significant benefits against significant harms that would result. I mean, it's quite clear to me that the development's contrary to the development plan. There are material considerations in favour of the scheme. They don't outweigh that conflict, and that's my professional.
I mean, the point of the planning balance is to weigh things against each other. That's why we afford weight to different things. And if you put your things that get benefit on a scale against your harms, very clearly the benefits are more.
No,
we've just
that's the appellant's position. That is not my position.
I mean, we've just gone through the list of benefits and the list of harms. I understand what you're saying, but that is just simply not a reasonable approach the council.
Well, that's the appellant's position. I understand that, but the council's position is that this application is contrary to the development plan, and material considerations don't indicate a decision should be made that doesn't accord with the plan.
Well, we'll have to make submissions about that in due course. But thank you very much, Mr. Reynolds. Those are my questions.
Thank you very much. I just go through that. I think you've covered most of the questions I wanted to ask, but I just need to check. And there's just one in your proof, paragraph 529.
So sorry, ma'am, is it 5129?
Yeah.
Yeah. Turn it up. Yeah, I have it. Yeah.
It's just about the business rates and local finance considerations. Given the definition of local finance considerations given in the 1990 Act, I just wanted to understand why you considered business rates were a local finance consideration.
Well, I've taken the view that it would be a local, it's a local finance consideration, and that it wouldn't be that the payment of the business rates would not be, it wouldn't make the decision, the development any more acceptable. It wouldn't be related to it.
Well, on what basis have you said it? Because, I mean, there's a definition in the Act of what a local finance consideration is. I'm just trying to understand, what have you used that as the basis?
I think I've used the PPG guidance from recollection. I've got the Town Country Planning Act. Shall I turn up the relevant section?
We're at section 74, 70 and part 4.
No, that's my mistake, Mum. On that basis of 4B, sums that a relevant authority has received or could receive in payment to community infrastructure levy. It's quite clear, isn't it, that it relates to community infrastructure levy. So on that basis, I would resolve from my position as regards business rates being a local finance consideration.
So that's kind of, therefore, that's part of the economic benefits.
Yes.
But I presume, well, are you saying still that it's limited?
I would still say limited, yes.
Okay, you've covered everything else. Mr. Platt, do you want re-examination?
A few questions, but I think the fire alarm's going up in 3 minutes.
Right, yes. So
I wonder whether we might do it afterwards.
yes, so have a break and do it afterwards.
Thank you.
Right, yeah. So we come back about 11:45. Is that all
Is
right?
that going to be okay in terms of how long we have to go out before I
No, it just goes off. It's just quite.
We don't have to do anything.
No, we don't have to do anything.
Other than
quite
cover our
loud.
ears.
Yeah.
Right, thank you very much.
Okay. Yeah. Yeah. Signed it.
Yeah.
So it's the air, isn't it?
Yeah, I was conscious of some
noise
activity out there, so
No,
we'll close it again when we come back, but yeah. Oh. Is that it? That's a bit underwhelming.
Yeah, I really thought it was going to be like. Ready? Yeah. Yeah.
Anyway, that is a copy of the conditions with all the comments on, and our list I've just produced, identifying the ones that we aren't quite there.
Thank you. Any chance we have another copy? Is that all right?
Get another one from the inspector.
Thank you.
Oh, that's fun.
That was right. Oh, yeah, it's slightly more budget. Yeah, yeah. Oh, yeah, yeah. Of course, we have to, because only enjoyment for land. Yeah, so this is, yeah, we about this. So we've got. Where.
broadly speaking, you're aware of those policy documents.
Yes.
And as a result, had you taken them into account when you considered the weight that you afforded to renewable energy benefits? There was a particular line of questioning that compliance with DES 7 doesn't really have any consideration or influence on climate considerations. Can we just turn up the policy, please? CD 5.1, page 202. I think.
I have it, yeah.
202, is it? It's 20. It's hard copy page 202. It's PDF page 204. So that doesn't really have an influence on climate considerations. The key policy is DES 9. That was the point. Do you remember that line?
I remember that line, especially, yeah.
Now, you went to Appendix 16 to this document in your examination in chief.
I did,
So
yeah.
let's go back there if we can. And can you please just tell us how, if at all, the local plan says efficient use of resources relates to climate, and how that mix in with policy DES 7?
So, yeah, I'm just.
I think the hard copy is page 341. The PDF is 343.
Yes, so you have the reference to the local plan policy on the left-hand column, and then you have explains which part of it relates. So you can see it's paragraphs, all of the paragraphs, DES 7. Wording that addresses climate change. It's point 7 that goes over the page onto 342, where it says avoiding the development of the best and most versatile agricultural land unless it's demonstrated to be the most sustainable choice from reasonable alternatives, by first using areas of poorer quality lands in preference to that of higher quality. And then the final column of the table deals with how this addresses climate change.
Yeah.
And it's the final part of what is a very long sentence that I think most relevant, which says avoidance of development of areas of, and then it goes over the page, best and most versatile agricultural land and reuse of previously developed land and buildings. So it's the reference to avoidance and development of those areas of BNV as contributing towards addressing climate change.
And what is the, just for clarity, what is that column called on the far right? What's the title of it?
It says how this addresses climate change.
Okay, so as to the allegation that DES 7, compliance with DES 7, the application of DES 7 has little to do with climate change, and we should all rely on, we should rely exclusively on DES 9. What does the local plan tell us?
Local plan is very clear that DES 7 is an important policy in terms of dealing with climate change,
Okay,
as is DES 9.
and stepping back logically, how is the efficient use of resource a climate consideration?
Well, it's particularly important when you're dealing with the most valuable land, in this case BMV land, where the NPPF requires us to recognise the economic and other benefits of it, using that land efficiently for purposes which BMV land contributes towards, i.e. typically the growing of crops, is an important factor. And we heard obviously that, you know, there was a poor yield due to extreme weather events last year. It's an important factor that we've got good land, that you are using it for the benefits that it can deliver.
You were taken to a number of policy documents, EN1 and EN3 in particular. Do any of them say anything about how solar development, particularly solar development at this scale, should be approached on BMV land?
No, obviously they're principally documents for the NSIP regime, and there can be material, and I accept they are material considerations in this case, but I say they're of limited weight, and they don't give instructions in regard to solar farms of this size.
Yeah, and in particular, as relates to best most versatile land, they provide guidance on that.
They do, and they're not out of step, particularly with the National Planning Policy Framework, in that they do require, where possible, that you avoid the use of BMV land and focus developments on, as a starting point, PDL, rooftops, non-valuable, non-agricultural land, and only then go through the hierarchy effectively, with BMV being the least desirable.
And that was my next question. I suppose you already answered. My question was going to be, how does the PPG and the framework tell us about how to approach development on BMV land? But I think you've just answered that.
Yeah.
Remind us, if you can, when was the PPG, when was the NPPF revised most frequently?
So it was most recently revised in December 2024. So it's literally hot off the press as an expression of the.
Well, there's a technical answer to that, but I can make submissions on it. As to the PPG, we've discussed, haven't we, that it can be revised any time. I don't need to ask questions about that. And remind us what Right Honourable Claire Cortino said in her 2024 WMS as relates to the use of best and most versatile land.
She said, obviously paraphrasing, but she said the more important or the more valuable the land, the less. I may turn it up actually, probably easier.
I think it's CD 3.63.
3.63. Thank you.
Might be 3.33. It's actually completely wrong.
I might have
6.33.
I've probably still got it open. So that's close a few things to reach the limit, but no, which one's that? So
Let's just this is, when was this written ministerial statement promulgated?
So this was May 24.
Just scrolling down, do you see that there's reference to EN3 in the second paragraph of the statement? Do you see that?
I see that, yes.
Okay, and then just tell us what the second heading is, despite that reference to EN3.
Protecting the best agricultural land.
Right. Then what's the key passage that you want to take us to here?
Yes, so it's essentially the bit that says the applicant should, where possible, utilise suitable previously developed land, brownfield land, contaminated land, and industrial land, where the proposed use of any agricultural land has been shown to be necessary. Poorer quality land should be preferred to higher quality land, avoiding the use of best, most versatile agricultural land where possible. And then if you scroll down, it's the penultimate paragraph in that section of the report on page 2. It begins, this means that due weight. So it says this means that due weight needs to be given to the proposed use of BMV when considering whether planning consent should be granted for solar developments. For all applicants, the highest quality agricultural land is least appropriate for solar development. And as the land grade increases, there's a greater onus on developers to show that the use of higher quality land is necessary.
Great. Thank you. I hope you've also got DES 7 still open. Will you just remind us, does DES 7, does it operate independently as a solo policy or as part of a wider plan?
So it's a policy which deals with the efficient use of resources. So it will cut across and be relevant for lots of types of development proposals that might come forward in South Oxfordshire district.
I just want to do all my DES 7s in one go. Put it that way. Yes, you were asked a question about DES 7. Let me turn on myself. So I haven't. You were asked a question about the first two lines. Says, I think in particular with the words "where applicable." Do you recall that line of questioning?
I do, yes.
Says effective use of protect natural resources where applicable.
Yeah.
What are the kind of circumstances where it would be applicable to consider those issues?
Well, certainly in circumstances like the appeal site, where you're dealing with a very significantly sized parcel of land that's development's being proposed on.
I think there was some suggestion that this is a policy that is really, in truth, somehow exclusively or predominantly concerning residential development. You recall that?
I do, yeah.
Just can you take us to the features of this policy that you want to highlight in response to that line of questioning?
Yes, I think it's the first sentence of the policy, really, where it says new development is required to make provision for the effective use and protection of natural resources where applicable. So it's not a policy which is related to any particular type of development. It applies to all forms of new development with the right where applicable.
And I think it was also said that there's only, or alluded to, there's only a limited conflict, or could only be a limited conflict with DES 7 because only one of its subcategories is in play, if I can put it that way, for the purposes of our case. Can you tell us, is there any scheme that you can think of that would engage all of these 8 criteria?
No, because it is a policy which deals with lots of different types. Has to deal with lots of different types of development. There are naturally some criteria which are more relevant to individual types of proposals, and that you heard the reference to housing, and bullet point 1 would be relevant there. But because it's dealing with a number of instances, it's inconceivable that a scheme would it would engage all elements of that policy.
So is it a case where the more criteria you don't comply with, the greater the conflict, or is there a different approach you want to apply?
No, you need a new development needs to comply with any of those limbs which are engaged. So in this case, limb 7 is the only limb that's engaged, and that's the limb that needs to be complied with.
Does DES 9 as a policy, I don't think we necessarily need to turn it up. Does it tell us anything about development on BMV?
No.
Does the local plan contain policies which govern development on BMV?
DES 7 is the policy which governs the use of BMV.
So when we're considering a development which includes BMV and includes solar, which policies do we have to consider?
Well, you absolutely have to consider both policies.
Right. Okay.
And any other policies in the plan that might be engaged.
And let's go, can we go to the Natural England, don't know what to call it, objection, not objection, is it? It's a supporting statement, consultation, that's right. CD 4.15.
I have it, yeah.
Thanks. Do you have it?
No. I've only recently closed it down.
Oh, I'm so sorry. I should have given you a list again. But...
I've got it now.
The document refers to, or I'm in the box, summary of Natural England's advice. Documents referred to the proposal resulting in the temporary loss of 20 hectares of BMV. Are we losing 20 hectares of BMV or more? I mean, technically, I suppose that's true, but...
So it says over 20.
Yeah, sorry, I said or more. are we a temporary loss of over 20 hectares of BMV?
We are, yeah, we're dealing with 57 hectares of BMV being lost.
So the point is what does that tell us about the specificity of this advice?
Well, it's general advice that you see issued regularly as simply standing advice, essentially, that natural England, because they are statutory consultee on developments that involve over 20 hectares of BMV land. So this is a standard response they send out when they're consulted.
Does the summary of advice, does it recognise the actual extent of BMV that's being released?
No, it's a generic letter that's designed to be able to be sent out, regardless of the proposal.
Okay, and let's just go down slightly in the letter over to page 2.
Yeah.
We have your authority. You see, this is the second paragraph. Your authority should therefore consider whether there's an effective use of land in line with planning practice guidance, which encourages the siting of large-scale solar farms, etc., etc.
Yeah.
Is that a reference to paragraph 13? I think
it is. Yes.
So my question is this Natural England response the end of the story, or are there further planning considerations that the letter encourages the decision maker to take into account?
Yes, it absolutely. The letter is, as I say, a generic letter which is sent out by Natural England, but as part of that letter, they were effectively deferring and asking the local authority to consider those factors, one of which is whether it's an effective use of land.
And yeah, we have also an express reference. We would also draw your attention to the PPG March 2015, so that's paragraph 13. They say we advise you to fully consider BMV land issues in accordance with that guidance.
Yes, I see that.
So is this an authorization from Natural England for the release of BMV, or are there further considerations at play?
There are further considerations at play. As I said, it's not a letter of support in any way, shape or form.
Just taking things slightly out of order, so I want to deal with everything in one go where I can. But yeah, let's pick it up there again. So I think you criticised. You said that there was no sequential approach, or there was a sequential approach as a matter of policy, and I said that you'd agreed that we didn't need to adopt a sequential approach as a matter of policy. And my learned friend said that you'd taken the point in your proof that there was a sequential test or sequential approach adopted. And I think the relevant bit is 4.14 in your proof. So I'm going to ask you to take it up, please.
I have it, yeah.
Just 1 second.
4.12.
The thing is, I've definitely got the wrong reference. I'm just maybe. Let me just 1 second. Sorry, Strauss. Yes, you're right. Thank you. Yeah, 4.12. So if you could just read that to yourself.
Yeah, I've read it.
Can you tell us whether in that paragraph you say that you think national policy requires a sequential approach, or do you say something different?
I say that policy DES 7 is consistent with the advice in the NPPF, and that it requires new development to follow a sequential approach, preferring use of poorer quality land only where this has been demonstrated not to be possible. Should the NV agricultural land be considered? So, in considering a preference, you need to consider at least two different things. So that's what I'm referring to there. Without considering alternatives, then it's hard. How can you demonstrate that you have actually preferred the use of poorer quality land? It's difficult to do that.
You gave the answer in cheap and you explained it in cross as well. Where in your analysis does the sequential approach come from? Is it in this case, is it something that's in national policy or something in local policy?
Well, DES 7 is a clear expression of the need to consider reasonable alternatives. So the NPPF national policy, all forms of national policy have a clear preference for poor quality land over EMV land. So yes, it's in my view, you need to go through some sort of thought process, a sequence to determine whether or not that test has been met.
And where, for the purposes of this appeal, is that sequential approach best articulated? Where can the inspector go to find it?
DES 7.
You were taken to the Bramley decision, which full document reference for which I think would be 7 something. Yeah, 7.11. Let's just turn it up very quickly.
Yeah. Yeah, I've got it.
My internet's actually just gone down, so that's streaming out for. Your internet's still working?
Yep.
Oh, thank you very
Yeah,
much.
mine
Thanks.
at the minute was struggling yesterday at times. But
Thank you very much. The key paragraph I want to go to is 178. You look at 175 as well. Why don't you read them in order? Read 175 and then 178. In fact, there's no need to read the whole paragraph. I'll read the bit that I want to talk about. So
yeah.
175, second sentence. Paragraph 13 of the PPG only requires that decision makers consider whether the use of agricultural land has been shown to be necessary.
I see that, yeah.
And then at 178, paragraph 13, PPG sets out a list of factors we need to consider.
Yeah.
And you see the second sentence, paragraph 13 envisages there will be a proposal involving greenfield land in which local planning authority should consider whether the proposed use of agricultural land has been shown to be necessary.
Yeah.
So insofar as there's a dispute over whether there is a requirement or the necessity be considered a factor, what does the court tell us about that?
Well, it needs to be shown to be necessary.
And you'll recall you were taken in EN3 to a passage which referred to there being no need to pursue a sequential approach. First obvious point, does that guidance, strictly read, does that guidance apply to a solar farm of this scale?
No.
Second point, is there a legislative direction about how to determine planning applications? Is there a statutory provision that tells us how we do it?
Yes. So we're dealing with a planning application under the Town and Country Planning Act. So section 38(6).
What does it tell us?
So it tells us that decisions should be made in accordance with the development plan unless material considerations indicate otherwise.
Right. And what's the development plan say about how we should approach
says that you should that you need to demonstrate, well, avoid the development of BMV unless it's demonstrated to be the most sustainable choice from reasonable alternatives by first using areas of poor quality land in preference to high quality land.
And we have your evidence about that, forcing a sequential approach. I don't think you go as far as to say a sequential test, but a sequential approach.
Yeah.
You've got that, don't need to cover it. Okay. I think that's it. Thank you very much.
Thank you.
Right. Thank you very much, Mr. Reynolds. You
Thank
can
you.
stand down, I'm sure you're right. Pleased about that.
Thank you.
So, so would you like to call Mr. Field? And I think you suggested about an hour for examination. So is that still?
Yeah.
Yes. So we should. I know that leaves you thinking about everything, but
That's all right.
you know.
Oh yeah. Plugging down there is one of the next notes. Might have enough chance. Yes. So.
Thank you very much. I've been to it.
Yes. So I'm going to start by introducing you from your proof, and I think that's the most important document we have up to start with. So section 1, it says there, your name's Alistair Field, you're Director and Company Secretary of Reading Agricultural Consultants. You have an honours degree in Geography and a postgraduate diploma in Master of Science in Agricultural Economics. You've been a consultant in agriculture and related issues for over 35 years, and you're a fellow of the British Institute of Agricultural Consultants, practitioner member of IEMA, and a member of the Institute of Soil Science. Is that all correct?
Correct, yeah.
And you say throughout your career, you've assessed the impact of developments on soils and agriculture in relation to major infrastructure projects, minerals, housing, flood protection, and a number of other types of scheme. And that's correct too.
Yes.
So I want to start, if I may, by asking you about the agricultural land quality and the use of agricultural land at the appeal site as currently stands. So could you just talk the inquiry through that?
Yes, certainly. Well, the site, as you have seen, the site was surveyed in detail by Soil Environmental Services. It was actually carried out in May 2020, so predated the data that we were given earlier. It was reported in August 2021. I'm not quite sure why there was such a delay for the report, but the actual survey was conducted in 2020. And that surveyed a wider area than the application field site, and it found 22 hectares of grade 2 land and 68 hectares of sub-grade 3 land. The application site was then reduced to avoid most of the grade 2 land, such that it now only contains 4.1 hectares. The remaining area of grade 2 is primarily in the location of the best. So it's in probably the best screen location for the best. And it's a small part of that large large field. So it is it is only estimates of land. 97%, 93 or 97%. I don't know. 3%, 52.6 hectares of 3A and 7%, 4.1 hectares of grade 2, and the distributions in figure 1 of my main evidence.
And so you were asked, sorry, Mr. Reynolds was asked a bit about the difference between grade 3A and grade 3B, and just a couple of questions while we're on this point. So you talked about the original BMV survey. I think you said, is that core document 1.16?
Yeah.
And so how do you go about distinguishing what grade land is? If you have something that's provisionally grade 3, provisionally grade 4, what is the process for actually reaching a conclusion about that?
Well, the ARC methodology, which is a core document, it sets out a very strict methodology for assessing the quality of agricultural land. So you need to extract the core of soil and basically record its properties. The main ones are the depth of each horizon, so the depth of topsoil, the depth of the outer subsoil, depth of the lower subsoil, the textures of each of those, the stone content of each of those horizons, the colours, because those indicate the degree of wetness and limitations from wetness, and the structures of those of those horizons as well. So once you've recorded all these parameters, you then assess them through, effectively it's a sieve. So everything starts at the top, and then you sort of filter down and things get knocked out one by one, and it's the most limiting factor which determines the grade. Now, probably about 95% of land is determined either by wetness limitation or draughtiness limitation. And the other main limitations are topsoil stone content, sometimes gradient, but virtually all are either too wet or too dry, or they can be both. They can be too wet in winter and too dry in summer at the same time. These soils have primarily been downgraded on because of drought. So the 3A soils are droughtier than the grade 2 soils.
And in terms of that process, I mean, how common is it in your experience to be asked when you're assessing the suitability of a particular site to test other landowners' sites in the wider area?
It's not.
And
We've never done it. I mean, we survey 5,000 hectares of land every year, and have done for 30 years, and we've never ever been asked to survey someone else's land.
And how practical would it be to start surveying other areas that are provisionally grade 3 within an 8-kilometre search area?
Well, it could be done, but it would take an enormous amount of resource. So for this particular, I've estimated there are 18,000 hectares in this 8-kilometre radius search area, and it's 18,000 hectares of agricultural land, so excluding Oxford and Ross.
Yeah.
That would take us 900 survey days to survey that.
And thinking a bit more about the difference between grades 3A and 3B, we had a local resident that came on the first day and said, this is particularly good quality land. I think there was some reference to accolades. I'm not sure exactly what that referred to. And in your view, is this particularly special agricultural land what is it able to produce and how common is that?
Overall, it's good quality land, but I mean that is the definition of subgrade 3A, is good quality agricultural land. I wouldn't put it any higher than that. It's really, I would say, nothing exceptional. It is within the category of best most versatile land, but it's the lowest grade within that category.
And there was some mention of how, because it's 3A, it's able to grow arable crops. I mean, are you able to grow arable crops in grade 3B land?
Yes, of course. The expectation is that the yields will be lower. If the 3B is 3B because of drought, there would be probably more cropped areas, but I mean the definition and the math guidelines of subgrade 3B is that it's land that's capable of producing moderate yields of a limited range of crops, but it's still expected to be cropped. Whereas by contrast, grade 1 produces high yields of a wide range of crops, so it's that difference.
And you heard Mr. Reynolds agreed that BMV land is not a rare occurrence, either nationally or in the district. Can you give the inquiry a bit of a sense of how common it is and how the appeal scheme relates to the prevalence of grade 3A or BMV land in the wider area?
Well, in the actual area search, there's actually very limited data available to determine the grade of land. There's only been 60 hectares of land that's been surveyed, that's published on Magic Maps. So that wouldn't include surveys that have been undertaken by private consultancies. But the information available, the detailed ALC information available on Magic Maps covers just 60 hectares within this 18,000 hectare area. So it's largely unknown, given that the provisional maps are not suitable for assessing the quality of individual sites or even of local areas. They are only to be used for strategic purposes.
Is there anything else you want to say about the appeal site BMV compared to the national level, or about the site itself and the grains it's able to produce, or are you happy to move on?
Well, I mean, it's clearly within the 42%, best most versatile in the country, or within the 57% of best most versatile land in South Oxfordshire. It's, I don't think it's exceptional. It's good quality land, but I wouldn't put it any higher than that.
And what sort of arable crop does this land produce at present?
Well, fairly undemanding feed wheat, feed barley, and a bread crop, or seed or.
Sorry, by feed wheats and feed barley, what do you mean?
Well, it's grain that goes into the to feed livestock, so it's not for direct human consumption. There's no meal wheat grown on the site, or even barley for beer.
And so, in that context, and also taking into account what you know more broadly, do you think there'd be an impact on food security from the development of the appeal scheme?
No, not at all. Absolutely not at all. Food security is not about the area of land that's in production. Food security is about distribution of food, with both globally and within this country.
And what's your view on whether there's a food security risk in terms of production of arable grains in this country?
Well, the country's basically self-sufficient in grains, other than the grains that we can't actually grow in this country that we need for bread making. And clearly we export a lot of grains as well. The national harvest is anywhere between 20 million and 25 million tons every year, mostly depending on weather conditions. So last year it was awful. But in the previous year, okay, and one before that I think was pretty good. This produces 500 tons of wheat, probably, which is just infinitesimally small compared to the national harvest, and it has no bearing on food security. For something like 500,000 hectares of arable land that are not cropped. So either they're left fallow or they're in environmental stewardship.
How much did you say, sir?
581,000 hectares. That's last year. And roughly about half of that was bare fallow. A lot of it because it couldn't be cropped because of the weather conditions. And roughly half of it, slightly more than half of it, is environmental stewardship.
And just leading on from that, what you say about environmental stewardship. So you've referenced in your proof the sustainable farming initiative, is that right? So I think we've got that in the core documents. PG 6.37.
I need to turn it up.
Well, you probably know it. I'm just giving the inspector the reference, but can you explain why you've referred to that document, and how that relates to what you say about lots of land now being in environmental stewardship?
Yeah, the Sustainable Farm Initiative is the new government support measure, but rather than paying direct payments to farmers will be encouraged to undertake environmental works, provide environmental goods to receive public money. And there's a whole raft of management agreements that farmers can enter into. One of them is to convert arable land into permanent pasture with low fertiliser inputs. And payment for that is £489 per hectare. So for the appeal site, that would equate to something like £27,000 a year that the farmer could receive from the government for converting from arable to low input pasture.
And is there a prohibition on BMB sites doing that?
No, any farm and any quality of land can convert.
And why is that initiative in place? What is the government trying to achieve by getting farmers to carry out that conversion?
It's primarily to meet environmental goals, primarily to reduce runoff into watercourses. It's a cheaper way of treating water, to treat it at a source and to treat it at the treatment works. To prevent losing runoff into the watercourses is a cheaper option than trying to treat and purify water. The treatment works.
And you've also referred in your proof to the soil health benefits from conversion from arable to pasture. Could you just explain that a little bit more for the inspector?
Those are primarily related to soil organic matter, soil carbon, and soil moisture. So, because arable cultivation releases carbon every time it's ploughed or disturbed, a lot of times a minimum tillage, but there's still a need for ploughing. Permanent pasture will keep carbon trapped within the soil, won't release carbon to the atmosphere. It also doesn't require the use of manufactured fertilizers.
And you provided some evidence of that in your proof about the carbon issue?
Yeah, those are from the laboratory that we use. But last year analysed 25,000.
With your
soil
5.31, where you refer to that laboratory and 25,000 soil samples, you say it's called document 6.38, I think. So is there anything else you want to say about that, or should we move on to the next issue?
Onto the soil organic matter. No, other than those, it's very clear that there are large benefits to be gained in terms of carbon sequestration and storing water and maintaining the land under pasture. So
There's another set of benefits that the appellant and indeed you have referred to in your proof in relation to this scheme and farming circumstances. And that relates to the benefit to the existing farmer in terms of the secured income from the solar scheme. So I think it would be helpful to just explain to the inquiry a little bit about the existing farming circumstances. So how big is the current farm and how would this scheme impact the ability of the farmer to continue to do arable elsewhere on the farm?
the farm is manages approximately 1,200 hectares, about 3,000 acres, all in the locality, predominantly in arable years. We heard yesterday from local residents that it was well-run farm, well-respected farmer, farming to a high standard. So it's a substantial area of land that they're responsible for managing in the locality, and they manage it to a high standard.
And so this, you say he manages, is it 1,200 hectares? You said
approximately, yeah.
And this scheme is 57 hectares. Is that right? So there's nothing to stop the farmer continuing to farm the rest of it.
No. It's a small proportion of the area that he farms.
And I mean, what do you see as the benefit to the farmer of this solar scheme on 57 hectares of his 1,200?
It's a diversified and secure income that the farm business will receive.
And I mean, you heard Mr. Reynolds' evidence about that. In his view, it's not farm diversification. I mean, what do you say?
Well, I say it's the second most popular form of farm diversification. The DEFRA statistics show that letting buildings out is the most popular form of diversification, and about 50% of farms let buildings out, as this is also the case here, that the buildings at Burcot farm are all let out for non-agricultural purposes. And the second most popular form of farm diversification is generating solar power, and that's carried out on 27% of farms.
And Mr. Reynolds said that the reason he doesn't think it's farm diversification is because the solar farm is operated by someone that's other than the farmer themselves. But when you let those buildings out in other types of farm diversification, is it always the farmer that's operating what goes on in the buildings?
Well, no, it's not, but there probably is more involved. Mr. Reynolds, that point, there probably is more management involved in running a set of buildings than there is in running a single contract.
And sometimes it's right, isn't it, that even on this farm, sometimes farmers let parts of the land out to tenant farmers.
Yeah.
And they let the tenant farmers run that piece of the land.
Yeah, I mean, most of the business doesn't own 1,200 hectares. Most of that land that it manages is rented in one form or another.
So thinking then about the impact of the appeal proposal on the 57 hectares out of that 1,200. So what's your view on whether any agricultural land would be lost because of the appeal scheme?
And in terms of the effect on the business,
or in terms of the appeal site itself,
appeal site, I mean, actually, no land will be lost. It's obviously the land will remain there. It will remain as agricultural land in pasture, but will have solar panels within it. In terms of the effect on business, it will provide a secure income to the business with the reduction of direct payments, which will be phased out for a year's time. This is the first time that the business hasn't made a profit, and it has been propped up by the other diversified enterprises. This, is the way that this particular farm has chosen to plug the gap that the loss of direct payments will bring back to an awful lot of farms.
And so you said there that no land will be lost. It will remain as agricultural land and pasture. So I've got two other questions on that. So one, I mean, obviously there are solar panels, but it might be said to you that there's an area that's also the access tracks and the BESS and the inverter. So what would happen to those both during the scheme and on decommissioning, and how much of an area is that?
Well, those clearly wouldn't be available for agricultural use or grazing use. So they amount to 1.8 hectares of land, and they would be in non-agricultural use for the lifetime of the project.
And how about on decommissioning?
Well, decommissioning, they would be restored to agricultural land.
And the other question I have for you is, so you said the land would remain as pasture, and need to talk a little bit about sheep grazing here. So is your understanding that this scheme would or would not propose to graze sheep?
Yeah, it's within the landscape environmental management plan that there would be a species-rich grass mix with, I think it was 20% wildflowers and 80% grasses. That would be allowed to flower, and then it would need to be cut in the summer, and then the aftermath would be grazed by sheep and or cut.
And in your experience, is that practical? Is it realistic? Yes. Is it fanciful?
It happens, yeah. It happens on other solar farms.
And Mr. Reynolds said he'd never seen sheep on a solar farm. Have you?
Yes. Yes, we've carried out a couple of resurveys of solar farm sites. The first survey probably a decade ago for clients just to look at the impact that any impacts on soil health, soil carbon, and both of those sites were grazed by sheep as part of their normal management. I live very close to a solar site that was grazed by sheep. We just submitted a DEFRA statistics that show that there are for the first time this year, they've recorded the area of agricultural land that's under solar panels. So they've recorded that there are 7,100 hectares of land in of agricultural land and solar panels, excluding any rooftops. And of that, I'm just trying to find it, 3,600. Okay, sorry about that. So they, for the first time this year, they collected data on agricultural land in solar panels. So they've got two categories. They've got the land used for solar panels and also grazed or used for agricultural production. That covered 3,600 hectares. And they've included that as in their permanent grassland category. And then they've also got solar panels on land not used for agricultural production, and that's 3,700 hectares. They've included that as other land on agricultural holdings. So basically half of the agricultural land that's in solar in the country at the moment is used for agricultural production.
Thank you very much. So I think maybe if we briefly talk about some policy points, because you do touch on these in your proof as well. So if we turn first to the NPPF, paragraph 187 has two parts to it. One is about protecting and enhancing soils commensurate with their status, and one's about recognising the economic and other benefits of BMB land. And so firstly, would this scheme protect the soils on the site?
Yes, it would.
And
yes, I mean, to the points we just mentioned about converting the arable land to two ways. The land would still continue to be in an agricultural use by sheep grazing, but also by converting arable land to permanent pasture. That would improve soil health. That would enhance soils on the site.
And would in your view the arable use be able to recommence upon decommissioning? Would the soil be able to do that?
Yes.
And is there a protection in a condition that would ensure the soil is protected in that way?
Well, there's a soil management plan that's a condition that will enable the soil to return to arable usage if required.
And then 187B talks about recognising the economic and other benefits of BMB land. How does this scheme relate to that provision?
I think we've just discussed that the economic benefits that are generated by this particular area of BMB land are really quite limited. The production of 500 tonnes every year of grain stocks for grain for livestock feed, where in the commodities in which there isn't a shortage, and there isn't really sort of any express risk. The other benefits that are offered by BMB land relate mostly to carbon storage, nutrient storage, water storage, and those all enhanced under pasture rather than arable. So those are a benefit.
And you had the discussion with Mr. Reynolds yesterday about whether the footnote 65 is a relevant policy for determining individual planning applications as opposed to plan making.
Yeah.
Can we just hear your view about that?
I think it's very clear that the footnote relates to paragraph 188. Paragraph 188 starts, plans should be clear.
So next, I just want to talk about the relevance of the 2015 written ministerial statement that's referenced in reason for refusal 2. What's your take on that in terms of how much weight the inspector should place on it, and to what extent you think it's relevant?
Well, my understanding of ministerial statements is that they are there for a serving minister to make a statement about government policy. Government policy will be what I'm telling you it will be. And this written ministerial statement didn't make it into the NPPF. And it's had 6 chances to do so since it was issued. So, you know, I don't think it is. I don't think it is government policy. Otherwise, it would be in the NPPF. But those compelling evidence is necessary.
And it's inevitably going to be put to you by Mr. Clapp that there's the recent Court of Appeal case. I don't know if you've had a chance to read it, of Mead realisations that he said he wanted to put in yesterday. And what that essentially says is that the PPG can have a similar legal weight to the NPPF. It also says the weight to give to different aspects of national policy depends in part on the date in which they're published, and a range of other factors, external circumstances. So what do you know about what this government considers in terms of the date of the PPG, which references the written ministerial statement? And does this government consider it still up to date?
No, this government has said that it's not up to date. It's out of date and it will be revised.
And then touching finally on the local plan. So we've gone through this in some detail with Mr. Reynolds, and noted that DES 9 does not refer to BNB agricultural land. What's your take on DES 7?
Can I give you my take on DES 9 first?
Yes.
My take on DES 9 is that I think BNB is a notable absentee from the sort of list of interests that could be harmed by a scheme. I mean, we carry out EIAs for all types of schemes, and we're always scoped in as one of the key topics alongside landscape, ecology, heritage, traffic, etc. So we're sort of used to being part of that list of key environmental topics that are affected by schemes, and not to be included in a list alongside ecology, landscape, heritage is quite unusual, really. So it's relatively, it's almost a conscious decision that DS 9 has made by excluding BNB agricultural land from the list of interests that might be harmed.
And how about DES 7 then, which obviously does refer to BNB?
DES 7, yeah, is, as I said this morning, it's the only reference in the local plan to West Northwest land. And it's looking primarily to, I read it as looking primarily to protect the natural resource of agricultural land. If you look at the list of the indents, there aren't actually many natural resources that are in that list of 1 to 8. There's water, air, and land, and the other 5 are not natural resources. So it's specifically, I think its primary aim is to protect the natural resource of agricultural land. But the scheme itself, obviously, does protect the natural resource, because it's not going anywhere. It's not being developed. It's not being taken into a reversible use from which it will never emerge. It's a completely irreversible development.
And so do you see DES 7 as requiring a sequential approach?
No, I don't. I mean, to start with, it acknowledges that there will be occasions when most versatile land will need to be developed, irrespective of any other sites.
Is there anything else you want to add at this stage?
It's a small point. It relates again to because I've only recently discovered that DEFRA have actually recorded the areas of agricultural land in under solar farms, and it's sort of related to the sort of scaremongering, but the concern about food security and taking land out of agricultural production is going to harm the national food security. Obviously, food security is a critical issue, just the same as energy security. But if 7,000 hectares that definitely recorded are able to generate 15 gigawatt of solar power, and that needs to triple to 45, 47 gigawatt, then that implies that 22,000 hectares of agricultural land will be required to produce that output. That is a tiny proportion of land that's available in the country. It's relative to the 581,000 hectares of arable land that isn't cropped. It's tiny, absolutely tiny. And so it's not the use of that land for solar production not only blind us to the difference to the production of food in country. There is food insecurity, but food insecurity is on a household level. It's to do with distribution, it's to do with wealth, it's not to do with production.
And before we finish, was there anything else you wanted to?
No, I think that's my little gripe.
But thank you very much, Mr. Field. I think we've been a bit quicker than we thought we would be, but that means everyone can go to lunch now. So that's it.
Yeah, that's great. Thank you very much. So if we break for lunch and we can be back for quarter to 2.
Yeah, that's right.
Can I just ask for my pass back?
Oh, right.
No, I left. I've got one that gets you through the door.
Sorry.
No, it's all right. No, I gave it. I volunteered it to enable people to get back in. I need to be able to get to the loo. So super. Thanks very much.
Alistair, do you want us to get you a sandwich?
I can do it, man.
Okay, up to you if you want to sit here or go.
No, I'm just great, man.
Okay. Over.
No, yeah. And the road.
I
Yeah.
okay. Okay. I'm not things that is fine. But what have you got? Have you cold compress or okay? Okay. Yeah, I don't know. Yeah, do. Was fine. It's like 1 o'clock, isn't it? Okay, so it's only got So as long as that doesn't have five.
Sorry. Yeah. You got sticky notes. If you want some of these. Yeah.
Yeah.
Back burn through them all, I need that.
Yeah.
Unlimited supplies.
I have. Well, I
I've got really big writing as well.
Right, well, it's 1:45, so we'll resume. Are there any housekeeping points that you raised?
Would it be helpful for us to discuss sort of timetabling? It seems to me, I mean, we'll definitely get through my cross this afternoon. I wouldn't like to start cross with Mr. Custom, but I don't think we're going to get there.
No, I'm not expecting to. I think let's see how long we take Mr. Field, and then see whether we start Mr. Custom or not tonight. We could, if necessary, if we've got time, we could bring the conditions forward to later this afternoon if needs be. I think that could be a relatively quick. I've just been looking at them over lunch. Or alternatively, we could do the conditions first thing on Friday morning. If I think I'm keen to do the site visit Thursday afternoon. I don't want to. I wouldn't want to kind of do the conditions Thursday afternoon, then go out on site, just because of when it gets dark.
Certainly from my perspective, I'd really welcome that period of time on Thursday afternoon to
do your
closing.
Closings, yeah.
As it is, that'll be relatively full-on exercise, even with an extra afternoon. So
yeah,
but I'm certainly grateful for that time.
Yeah. So I mean, it may. So I certainly want. That's my feeling. So it's the conditions we can move around. To either do first thing on Friday or maybe this afternoon later on, if just depending on what the time is. I mean, I prefer not to have people in isolation all night, if possible.
It was nice not to have to talk to Mr. Reynolds yesterday.
Yeah. I don't know. I know what it's like being really no mates. So
No, it's normal for me.
So let's we'll play it a bit by ear, but there's things we can shuffle around.
Thank you.
Yeah. So Mr. Clark, I invite you to about your cross-examination.
Good afternoon, Mr. Field.
Afternoon.
You are, as it says in your proof, an expert in agricultural land matters. That's right, isn't it? So that's agriculture, agricultural economics, rural land use, soil science, etc. You're not, I don't think, and you don't profess to be an expert in the interpretation of planning policy.
No.
It wouldn't make much sense, would it? Mr. Custom's here, he is.
Exactly.
So I'm going to cover some policy matters in due course with him. Am I right in thinking that you're happy to defer to him in respect to questions of policy?
Yes.
I'm in a bit of a difficult position because quite a lot of your proof is about planning policy. I hope you won't take it to heart if I don't ask you about all of that.
You're entirely, you can ask me what you like.
Okay, but don't say that. So the way I'm going to approach it, I hope it's all right with you, is I'm going to ask Mr. Custom the bulk of my planning policy questions and take up a few matters with you. Okay?
I'm happy with that.
Okay. And we're here to talk about reason for refusal 2, fundamentally, aren't we? And would you agree with me if I formulate the issue in this way? It's fair to formulate the ground in this way, that the ground alleges that B&B at the site is valuable and its loss is not adequately justified.
That's what reason refusal says, yes. And
That's in essence, I mean, it's not what it says in so many words, but in essence, that's what we're talking about. Is that fair?
That's the reason for refusal.
Okay. So can we agree that BMV is a valued resource in the planning system?
Yes, it's a consideration that carries weight. I mean, it's an acknowledged receptor. It has very little indent in paragraph 187, the MPPF. It's an acknowledged receptor.
And we have done, we've mentioned 187A. I'm going to pick that up with Mr. Cusson. We've mentioned, you mentioned 187, which your dimension is 187A. You would have read, no doubt, 187B as well. And we have this paragraph, plans should prefer development on areas of poorer quality agricultural land. There's a higher quality, that's paragraph 188. Just picking that up, if I may, while we're there, you said that that was a paragraph that referred expressly to plans. That's of course right. I don't argue with you about that. Will you accept, will you agree with me that that's capable of being a material consideration in this at the decision-taking stage?
I think that's probably a matter of planning law on which I'm not qualified.
Okay, well, I'm only asking you, again, I don't mean to be unfair, but you were very clear in giving your answer about the analysis of the NPPF, and you said you were asked about it, and you said plan should is the key thing.
No, the reason I say that is that I mean I understand that material consideration has a legal meaning. Yeah, and I'm not clear what that legal meaning is, so I want to tread carefully in how I use the word material consideration, but I'm not certain that's the legal implications of that.
Do you think it could be relevant for the purposes of this appeal that paragraph is included in the NPPF? Is the essence of what I'm asking you.
I think the relevance of that paragraph is that it directs plan making, and the way it's come out in this appeal is that it has directed the local plan to include its policy on DMV land.
Yes.
That's it, isn't it? That's the purpose of the paragraph in the MPPF, to direct owners how to draw plans, and that's manifested in the local plan.
Yeah, so you'll agree with me then that the policy in the local plan that deals with BMV land, DES 7, which talks about, gives effect to that paragraph of the MPPF.
Yeah.
I think we can agree with, we've agreed BMV is valuable to obviously material consideration. Not going to ask you about that, don't worry. Can we agree that the weight the planning decision taker gives to loss of or interference with BMV is a matter of planning judgment?
Yeah.
And I think we've covered it already, but will you accept that the greater the loss BMV, the greater a loss of a valuable resource, the more justification will be required for
it? Yes, I think that's so.
And you set out at 2.6. I don't think it's necessary to go to this in my note for some reason. Yeah, so at 2.6 of your proof, you tell us what grade 3 land is. The inquiry's heard about this already, but I've got to cover it just for completeness. So we've got grade A is a subdivision which is BMV, correct? Grade B is a subdivision which is not. So it's wrong, isn't it, to characterise all grade 3 land as being of the same standard?
Yes, it's not. And it's only now subdivided because originally the classification system only had 5 grades. It didn't subdivide grade 3.
Yeah.
It then subdivided grade 3 into 3 subgrades, so the A, B, and C. but that got too complicated. So it removed C, and just had grade 3A and 3B. But I mean, if they were starting again,
Might be 3, 4.
yeah, exactly.
3A is 3,
If we
3B
want
is
to do
4.
3, 4, 5, 6,
Okay, yeah.
probably.
Well, let's
Starting again.
yeah. Well, let's not get into
But
a different kind of sequence that I don't want to
Yeah.
talk about.
that's what you've got the 3A, 3B.
Yeah. Gotcha. Okay.
And once upon a time, best most versatile land was just grades 1 and 2. So in the late 80s or early 90s, it was defined in one of the PPGs, PPSs as just grade 1 and 2.
Yeah.
And then 3A came in one of the PPSs.
But we've got to assess the position as it is now.
Yeah.
Position is as I've set out. Are you happy with that?
Yeah.
Okay. And it's important then, particularly in like what you've just told me, to recognise the difference between 3A and 3B land, because one subdivision is a particularly valuable entity in the planning system. That's B&B land, and the other isn't. That's right. So it's important. I can record. It's important to recognise the difference.
Yes.
We know we've covered this already. It's in my notes, so I'll bring it up with you. 100% of the site's B&B land, and that's 7% grade 2, 93% grade 3A ish.
Yeah.
Okay. I want to ask you a few background questions about how you understand the farming circumstances, if I can put them like that. The background way the farm works. The farm's been there for 6 generations. It's fair to since 1956.
No, that's when it was incorporated.
Exactly. Okay, so it was there before
Not that fast
1956.
reading.
Yeah, yeah. I make no comment on that particular issue, but it's been there since before. Do you know when? Just so I can record it.
No, I don't. I don't.
Okay.
Around, but I mean, probably going back to the late Victorian era. So I don't.
Okay. I'm not going to hold you to that. Don't worry. And is it fair to say, question is rather obvious, but since the late Victorian era, the economic climate has at times been poor, at other times it's been better for the purposes of farming?
Yeah, that's hugely different.
And at times during that period, of course, that's made farming itself more profitable for farmers, relatively speaking, and at times less profitable for farmers. Who agree with me about that? And of course, the enterprise has endured for all of that time, hasn't it?
The business has, not the enterprise. But the enterprise has changed.
Yes. Okay. The business.
The business is.
Yeah. Okay, that's quite right. I'll change that note. And we had relatively recently, is BSE had a major influence on the approach to farming at the site?
That wasn't recent.
Well, I said relatively recently.
40 years ago now.
Yeah. Well, yeah, I know. But you take my point. It's a relatively recent development, had a major influence on farming because they no longer farm.
There's been all sorts of shocks to farming. BSE put them out. Brexit, common agricultural policy, all had their effects.
Okay. And that BSE resulted in a relatively big adjustment because there's no dairying in the farm anymore.
Well, it was, BSE put an end to the beef enterprise. The beef enterprise is the offspring of the dairy cattle.
Right.
The dairy cows. So put an end to that particular enterprise. We put an end to dairying itself. That followed later, and that wasn't as a result of BSE.
The only reason I put it that way is that in your proof you say the farm used to be in dairying.
Yeah.
And then you say, however, the outbreaks of BSE led to the decision to cease rearing beef cattle. Am I right in thinking, nothing really turns it, am I right in thinking that they stopped producing cattle for meat and that had an impact on the dairy, which then went away?
No, the beef enterprise was just the male offspring of the dairy cows,
Right.
which are otherwise sort of sold at, you know, the gold or whatever.
Mm.
So this is just to create some value from those offspring. We've got some vegans in there. So I don't want to upset too many people, but
Got some what, sorry?
got some vegans in the room. So I don't want to upset the male offspring will otherwise, you know, likely be culled at a very young age. The full beef enterprise is just a means of giving them a little bit longer to live and securing, you know, getting some value from them, turning them into beef. Once that finished, the dairy enterprise will still continue, but there'll be other ways of moving the male spring on.
Okay. Right. But that's one of the shocks, as you put it, shocks to farming that's taken place over the last.
That had a huge impact.
Yeah. Okay. And as you said earlier, the farms remained viable during that period, didn't it?
Well, yes, but that's when they started to diversify. So
yeah,
that's the point at which they started to look for other income from the buildings of Burcot farm.
I want to ask about the WMS. I want to look at what the text of the WMS actually says. So can you turn it up, please? It's the document at CD 6.32. Yeah.
Yeah, cool.
And the particular element of this WMS that is contested between us, I think, is the provision that says any proposal for a solar farm involving B&V land would need to be justified by the most compelling evidence. Do you see that?
Mm-hmm.
Would you agree with me that it's relevant, this WMS is relevant for the purposes of this appeal?
No, I think it's out of date.
Okay, we can come on to that in a moment. Just reading the words of the statement, they're unequivocal, aren't they? They say that solar farm on B&V will need justification, and the justification required is the most compelling evidence. Leaving aside the question of whether you say it's out of date or not.
Yeah, that's what it says.
That's what it says. But you say, of course, that the WMS did not find its way into national policy. That's what you say in your proof of 420, right? But we know, don't we, that the PPG is a material consideration. I think we don't need to stray too far into planning law to ask you about that. We know the PPG itself is a material consideration, don't we? Will you agree with me about that?
Yes.
And will you turn up the Mead realisations decision? It's the one that I circulated yesterday.
Yeah. It's got a CD reference.
I don't think it has a CD reference. I think it's probably gone.
It's an inquiry document.
That's in
5.
Oh, yeah.
Do you have access to it?
I've got it on the emails, I think.
There is a separate folder on the website titled Inquiry Documents. They're all in there rather than in CDs.
That's just taking around in a circle.
If you Google Mead realisations Court of Appeal, you may be able to access it that way.
I say that it was sent to me by the office this morning as well. Yeah, I've got it now.
Do you have it?
Yeah.
I'm grateful. The paragraph I'd like to go to is paragraph 33. Do you see the first line of that paragraph towards the end of the line? Pick it up. The legal status of the government's planning policies. Do you see that? Paragraph 33.
Right. Oh yeah, first line.
The legal status of the government's planning policies in the NPPF and its guidance in the PPG is basically the same. No legal distinction exists between them. They're not legislation, their status is equivalent in the sense that both of them are statements of national policy issued by the Secretary of State when exercising his general power to do so, etc., etc. Then, towards the end of the paragraph, final sentence, both the NPPF and the PPG are national planning policy in this broad sense. You see that?
Yeah.
And the broad sense, to be completely fair, is the fact that they're an expression of the Secretary of State's view of planning policy. I think that's what it means.
Yeah.
Do you agree with me about that?
Fair enough. Yes. Yeah. And that was Mr. Pickles' view in 2015.
No, that's not Mr. Pickles' view in 2015.
No. But the PPG on Amanda Taylor was, and the written ministerial statement of 2015 was Mr. Pickles' view of planning policy in 2015.
Well, we haven't
consistent with paragraph 33.
We haven't quite got there yet.
Right.
So what we've agreed there is that the PPG is an expression of national policy, I think. That's what the Court of Appeal say about it.
Yeah, it's what it says. It's a statement of national policy issued by the Secretary of State.
Yes. So the reason that I brought this up, so I'm so sorry, what did you say?
It's issued by the Secretary of State when exercising his general power to do so as the minister.
Yes. Yeah. So when you wrote, well, take it back a step. Will you agree with me that the 2015 WMS is referred to in the PPG?
It's a C also.
Yeah. Okay, we can come on to that if you want. And we've just agreed that the PPG is an expression of national policy.
Yes.
So when you say, as you do in your proof, the WMS did not find its way into national policy, that is, as a matter of law, wrong, isn't it?
I will take your legal judgment on that. I don't know that as a matter of law if that's right or wrong. I can't answer that.
Well, look, we've just taken you to the key bit of the judgment. I've spelled it out. It's very clear what it says. But
there's
not trying to be difficult. I think that's it.
There's often conflict between the NPP and the PPG.
Yes, yeah. I'm sure there is at times, but the point I'm dealing with. Sorry, just let me ask the question. The point I'm dealing with at the moment is your assertion that the WMS is not part of national policy. You don't qualify that assertion to any extent. You just say it's not part of national policy. And what I'm saying is that it is.
Oh, I see. That's fair enough in that case. Well, what I would probably express better is that it isn't in accordance with the NPPF. And I would give, and I don't know if I'm correct in doing so, but I would give prominence to the NPPF because it's up to date and it is it's regularly revised.
Well, it's interesting that you should say that because actually one of the things that comes out of this Mead realizations decision is that one doesn't trump the other, and actually the PPG can materially alter the policy and the framework. But that's a legal submission. But were you aware of that?
I did. Yeah, I've only actually skim read this.
Right.
But,
okay.
But it's, in my mind, it's relevant that the MVP and the NPPF has been updated, numerous times, 6 times.
Yeah,
since 2015.
I completely agree with you about that. The next line of question I'm going to pursue So you say that, don't you? You say it's been updated 6 times since the 2015 WMS. I think it's probably 7 now, because there was one the other day, wasn't there? The 2015 WMS has remained in situ in the PPG for all of those revisions, hasn't it?
It has, yeah.
And at every stage, every day, in fact, that the MPPF has been enforced, there could have been a revision to the 2015 WMS. It could have been removed from the PPG. And at no stage
Plus, the PPG itself could have been updated.
Sorry?
The PPG itself could have been updated.
Well, yeah, quite. And that could have been overnight, no consultation.
Yeah.
Yeah. But if I could put it this way, that would be an incredibly easy step for the government to take, wouldn't it? Not like changing, they wouldn't even have to change the wording of the policy, they could just remove the C also, as you put it.
Yeah.
But they haven't undertaken that step at any stage.
That's fair.
Despite these overarching changes to the national planning policy framework. Do you not think that suggests, will you not agree with me that to some extent that suggests that the 2015 WMS is something the government wants to rely on?
No, I think it just implies it's very low priority for them.
Well, so what you say it's low priority? I think you say it's so out of date it doesn't really apply.
Yeah,
so why is it still there? Is that some sort of mistake?
I don't know. I can't answer that. But it just strikes me as it's something that hasn't concerned.
Well, no, it must have done, because it's directly contrary to what your client says is the prevailing picture as to how we put together all this renewable energy stuff. We've got this obstacle of a policy, 2015 WMS. It's in the way, really. That's why you're arguing it doesn't apply, is because it doesn't help you. It's in the way. If the government was so earnestly trying to pave the way for all this renewable energy development at any cost, it could have removed this BMV provision, couldn't it? But it hasn't.
It could have. And it says it will do.
No, it doesn't. We'll come on to that.
But,
will you agree with me that its retention is significant to some degree?
I think I don't know. I don't really know, because I don't know the workings of central government. I think it's possibly lazy, possibly an overthought, or it's just so low priority for the government of the day that it wasn't considered necessary. I don't know. I haven't been in central government for the last 15 years, 10 years. The current government has indicated that whole guidance in PPG is out of date.
Well, we'll come on to that in a moment, as I say. But there has been, hasn't there? There's another WMS, May 2024. Claire Cortina is the minister.
Yeah.
We went through it to some degree. We better turn it up. 6.33, please.
Yeah.
Do you think it's fair to say, in consideration of the fact this is a statement of policy about renewable energy and about BMV, that the minister in this case would have been aware of the prevailing policy position prior to making the statement?
Yes, because this statement basically reflects policy in the N3. So, and she refers to that a couple of times within the statement. So yes, she clearly was aware of the N3.
She's aware of the prevailing policy, you say? Yeah.
Well, she's certainly aware of the N3.
Well, we've got to be careful, because we're going to record this and make submissions of it in my
PPG or even the MPPF, I think.
No, but the question I asked you was whether it's fair to attribute to this minister, who's giving relatively specific advice about renewable energy and BMV, background knowledge of the framework and the PPG. Is it fair to assume that she's aware of those matters?
If she was competently briefed.
Yeah, okay. Okay. Well, let's assume, I mean, that is actually quite a big leap, but let's assume she was competently briefed. She would have been aware of 2015 WMS, right? And its inclusion in the PPG.
Let's make that assumption. I have no idea.
Okay. Assuming. Let's just turn it.
If it's of interest, I know why this written statement appeared, because it immediately followed parliamentary debate, and the parliamentary debate was instigated by a handful of rural MPs with DCO solar farms in their patch.
Okay.
And there was general outrage, and this ministerial statement followed that debate in the Commons.
So we've got a reference, haven't we? I've done this with Mr. Reynolds already, but yeah, got a reference to EN3 in the second paragraph. Then we have this heading, protecting the best agricultural land.
Yeah.
And you refer to it in paragraph 4.25 of your proof. Now, this is precisely on point for the purposes of the issues in this inquiry. We've got, isn't it? I'll summarise why it's helpful. I say it is because we've got reference to the importance of solar development, and we've got the importance of BMV. So it is a statement which reflects those two issues. It is an opportunity, this was an opportunity to reverse or at very least indicate the 2015 WMS was wrong or outdated, wasn't it?
There's also an opportunity to confirm it was the correct test. It doesn't refer to compelling evidence.
Well, this isn't the WMS that makes its way forward into the PPG, is it?
No, but I mean, she's spelling out policy as appears in EN3, basically. And she hasn't then used the compelling evidence test, and thou shalt not use agricultural land for solar farms.
The question I asked you is whether this was an opportunity to reverse or indicate the 2015 WMS. It doesn't use any wording to the effect that 2015 WMS is wrong or outdated, does it?
It doesn't refer to the 2015 WMS.
Could have done.
Could have done, but it didn't.
Could have referred to the PPG.
Could have, but didn't. It refers to recent policy statements in EN3.
Of course, those apply to different threshold development. I know they're material, but apply to different threshold, don't they?
Yeah, but she's applying them to all solar developments in this ministerial statement.
Yeah. And of course, this WMS has not been picked up, referred to in PPG. No?
No, the PPG hasn't been updated since 2015.
Well, that bit hasn't, to be fair.
Yeah.
Right, so let's go to this Green Power Action Plan 2030. H27 is the core doc reference, please. Thing. I think the relevant bit, page 54.
Mm-hmm.
You there?
Page 54, developing business models for hydrogen transport.
I think it's probably internal page 54, is that right?
Powering up Britain. Am I in the right document?
Yeah, you are, yeah. Clean Power 2030.
Oh.
You're not in the right.
I'm not in the right document.
Right. Okay. 827, please.
Oh, sorry, as an X20. Sorry.
That's all right. It's PDF page 54, which I think is the same as the hard copy numbering. All right.
Yeah, on page 54.
Do you see there's a heading for locally consented energy infrastructure? You see that?
Yeah.
And in that paragraph, we've got a sentence beginning currently. Can you see that?
Yes.
I'm just going to read it. We can all read it together. Currently, the NPPF does not make clear that local planning authorities should consider the benefits associated with renewable energy generation and proposals' contribution to meeting a net zero future when determining planning applications for these developments. Does that statement say anything about the evidentiary threshold that might be imposed on B&B land?
No.
Fine. Okay. And the next sentence says the PPG, which adds further detail to the policy contained within the NPPF, contains outdated guidance, which requires updating to reflect new policies. So the point I want to make, the thing I want to raise for you to comment on, is that the relevant part of the NPPF that is referred to immediately prior to this statement that the PPG is out of date has nothing to do with B&B land or the compelling evidence threshold, does it?
No.
So the short point is that we don't know, do we, which bits of the guidance may change or may not change in the future, do we?
Well, we know the planning practice guidance for renewable energy
Yeah.
will change.
Yes. We don't know which part of it's going to change, do we?
Not specifically, no.
And in fact, as you've just agreed, the bit of the framework, which is reflected in the PPG that's being discussed in this paragraph, has nothing to do with B&B. You agreed that earlier, right?
If those two sentences are in sequence, yes, then if the second sentence necessarily follows from the first, then that would be the case.
Well, they're all in the same paragraph.
They're all in the same paragraph.
You can see the submission.
The last sentence in itself just says the planning practice guidance for renewable energy will change, will be updated.
Yeah. Just so we can leave this topic, the sentence immediately prior is about the NPPF.
It is.
Right? The PPG is said to add further detail to the policy contained within the NPPF. Is it fair to assume the thing that's out of date is about the PPG, which refers to the bit of the NPPF that's been discussed in this paragraph? That's the point I'm making.
Well, I'm not sure that's the case if the permission is that actually that the PPG didn't make any reference to the matters in previous sentence.
Yeah, okay. Well, those could be included, couldn't they? It could be brought up to date by making clear that local planning authorities should consider the benefits associated with renewable energy generation. Right? Then it reflects the NPPF. Then it's up to date. That could be what it's saying. Okay. And the inspector, this inspector is obliged to apply the guidance as it is, isn't she?
Yes.
And we've already discussed what that is. You say there are a number of appeal decisions which support your thesis that the compelling evidence threshold doesn't apply. That's what you say at 511. Is that fair? You say this interpretation of policy has been repeated on numerous occasions in recent appeal decisions. Yeah.
Yeah.
So let's go through them. CD 7.23. This is land west of Thaxted. Yeah.
Sorry, I think I'm losing control of my mouse. I'm sorry. Yeah.
Okay. Decision of 18th of December 2023, relatively recent. So obviously it's one of the decisions that you refer to in your proof. We go to paragraph 93.
Yep.
That's an expression of what we've discussed, expression of the text of the WMS, yes?
Yep.
And can we go on? That's before the paragraph you mentioned, which is paragraph 96. I think that's one of the ones you mentioned, right?
Mm-hmm.
And then at paragraph 166, if we could go there. The inspector says, I recognise 2015 WMS requires the most compelling evidence for development of solar farms on B&V, right? See that? And then we have, quite properly, this is the bit that you refer to, this must be read in light of more up-to-date events. I'm not going to go through them, but I'm not trying to not highlight them for the purpose of this inquiry. I'm not trying to sweep them under the carpet. I accept that there's a reference to more up-to-date events, which is, I think, the point that you make. But if we go to the end of that sentence, please. The inspector concludes together with the specific considerations in this case, I conclude that these factors provide the most compelling evidence to justify the use of BNB in this instance. So two things I want to ask you about. First thing, will you agree with me that the specific circumstances of the case were relevant for the purposes of determining whether there was compelling evidence or not?
Yes.
Each case turns on its facts. Will you agree with me that the inspector did actually apply the compelling evidence threshold, but just found it to be met?
Yeah, I mean, she listed every relevant policy and consideration that she was required to have regard to.
Yeah, but the conclusion
and I suppose the 2015 WMS was the highest bar. So I read that as even meeting the highest bar the considerations in this case, together with climate change emergency and all the rest of it in that same paragraph, provide the most compelling evidence.
There is no sentence in that paragraph that indicates that the inspector has adopted compelling evidence as a threshold, as some sort of fallback or fail-safe or highest bar, is there? If there is, take me to it, because I can't see one. The question that I'm asking you...
No, I mean, she sets out, I mean, very fairly, going back at paragraph 95, and she sets 95? Yeah. So we've got a, this is under the agricultural land section. We've got paragraph 91 on the local plan policy, paragraph 92 on paragraph, what was then 170B of the NPF, paragraph 93 on the written ministerial statement, paragraph 94 on the PPG, paragraph 95 on the NPS. So she's gone through the whole raft of documents that she needs to take into account in meeting, in reaching her conclusions.
I don't want to be...
And clearly the highest bar is the 2015 most compelling evidence. That sets a much higher test.
Yes, it does.
Than any other of the documents that she's listed there.
Yes, it does.
Been very exhaustive in listing the policy documents that need to be considered.
I know your cases that you've demonstrated compelling evidence, and I know that's the appellant's case. I need to ask you about this threshold because your proof says that the compelling evidence threshold doesn't apply. So that's what I'm exploring with you at the moment. I'm not exploring with you whether you think compelling evidence has been demonstrated or the renewable energy policy position is such that it overrides all other considerations and amounts to compelling evidence in every case. I know that's what you're going to say. I'm asking you whether, in this case, the inspector has applied the compelling evidence threshold. You said yes. I think we agree about that. And then you indicated that the inspector had applied it as some sort of fail-safe or highest policy threshold. Now, it is the highest policy threshold. We say it's the highest policy threshold because that's the policy threshold that applies. I'm asking you whether there is any indication that the inspector has applied it on some sort of precautionary basis. And I've asked you to go to a bit in the paragraph to justify that analysis. And you took me to all over the shop in the appeal decision.
No, I took you to where she set out the policy that she's assessing the appeal against. And she's listed all the policy considerations that she needs to have regard to, and she's included the 2015 WMS in that. That clearly sets a much higher test than the other policy documents, and so I think she's almost duty bound to consider it. If she's considering it against each of those policy documents, she has to consider, she has to expressly state and consider the one with the highest bar.
I'm going to take she's duty bound to consider it from that. I don't understand what you're saying about this highest bar point. The submission I'm going to make is that compelling evidence is the requirement in the 2015 WMS, and it's the requirement's been applied in the final paragraph of 166. Do you want to say anything else about that before I move
on? But it's not the only. Yeah, it's not her own consideration, is it? She hasn't just looked at the 2015.
No, of course, she's looked at the factors that they take into account material consideration. The point we're getting at is that there is a threshold. I say it's referred to in the final sentence of paragraph 166. I don't think you're really disagreeing with me about that.
But if you read 166, it follows the last sentence of 165, obviously.
Comes before 167 as well.
And I mean, they're concluding the weight that she's attaching to the loss of land for the 40-year period, and considering the conflict there with the land policy and the national policy and guidance. And then she says, that said, nothing in local or national policy puts a moratorium on the development of such land where that has been found to be necessary. Then she talks about the 2015 WMS, and she might have been doing that in the light of the 2015 WMS, effectively saying, thou shalt not develop on best most versatile land.
I'm afraid I don't understand your answer.
But that's an interpretation of those two.
Well, we can pick it up with Mr. Custon if we have to. Let's go to 729 next. 729, please. Little Cheveney Farm. Is it just? I hate to bang on about it. It's remarkable that you've adopted that interpretation to 166, because at 515 of your proof, you say, even if the 2015 WMS still carries weight despite its inconsistency with national policy, and if compelling evidence is considered to be the relevant test, inspectors have repeatedly found that yada yada yada. This is exactly what I've just been asking you about. You've given it up in your proof. Now you're saying it's not the relevant test.
No, it was an even if.
What I was asking was,
my evidence says I don't think it applies because
I know that's your evidence. What I was asking you was,
I'm covering myself there by saying even if the situation was that 2015 WMS does apply.
Yeah. No,
then,
I know. What you say is that inspectors have recently found that the urgent need to address climate change emergency comprises that compelling evidence. So it's necessarily the case that those inspectors have deemed compelling evidence to be the threshold. That's what I was asking you about, whether that was the applicable threshold in that case. But we can move on to Cheveney, right? Let's do Cheveney. Paragraph 51 in Cheveney. I am satisfied that there is ample compelling evidence for the use of this land. Paragraph 52. There is compelling evidence that its use would be acceptable. So the question I'll ask you again about this case, will you accept the inspector in this case applied compelling evidence as the threshold?
Those thinking very much. I'm just trying to find where the concept of planning policies that he was considering.
You don't think the words, I am satisfied there is ample compelling evidence for the use of the land, is an application and a conclusion of a threshold that the inspector found to be crossed? Again, I'm not trying to get you to say that there is not compelling evidence for this development. We can come on to that in a minute.
No, but I'm trying not to read those paragraphs out of context. That's all I'm saying.
I'm not trying to get you to read them out of context.
I'm just looking at the. Sorry. I'm not sure he refers to the 2015 WMS.
Wasn't the question I asked.
I mean, he might have been using. If he in policy and guidance, so paragraph 7 to 10, he doesn't reference.
He does at 45. We just shortcut that.
Oh, thank you. Other guidance, it doesn't reference it.
Yeah. Can you read that? 45, 46. I mentioned here the WMS of March 2015. 46, he says, the WMS did not alter the underlying message that the use of BMV must be properly justified. Yeah.
Yeah, see that then. Yeah.
And then we go to 51, 52, the end of that particular section under BMV land, drawing things to a close, drawing the analysis, the threads of the analysis together. I'm satisfied there's ample compelling evidence. There is compelling evidence that use would be acceptable. The question I asked you is, the inspector applied the compelling evidence threshold from the 2015 WMS, didn't he? Or she?
Probably need to take a bit longer to do the whole decision, to be honest.
Well, I'm not sure it does. It
There's
does
quite a lot
require that.
there, and it doesn't seem to me that the 2015 WMS is at the forefront of this decision. It doesn't strike me like that at all. I mean, might be using language of the 2015, but absolutely. I mean, there's no, you know, just concluding there. There's no conflict with the objectives of the local plan policy.
I know it says other things. I'm asking you about whether it's applied. He's applied the compelling evidence threshold. I'm struggling as to why we've had to take so long on this, because I told you that the WMS is referred to in the body of the appeal decision, right? Twice. The inspector is clearly aware of it, and the very threshold, compelling evidence, from the 2015 WMS is referred to in the concluding paragraphs of the appeal decision. You can disagree if you want that the compelling evidence threshold was not applied, but if you do say that, I'd like you to explain how. It's okay, let's move on. We'll go to 743, CD 7.43, Poplar Farm. You there?
Mm-hmm.
Decision of March 2024, the agreement is relatively recent. Paragraph 17, we're going to start at. Refers to the WMS expressly. Yes?
Yes.
Will you just tell us what the inspector says next, after quoting from the WMS?
Although nearly a decade old, it remains extant and referred to in the National Planning Practice Guidance. Therefore, continues to form part of government policy on relevant development.
Yeah. Okay. As we know, compelling evidence is the threshold. Compelling evidence threshold is referred to at paragraphs, let's go to 42. See that? Compelling evidence is the threshold there?
Mm-hmm.
Do you see referred to again in 43? This document forms part of the compelling evidence in favour of justifying this proposal. See that?
Yeah.
44. refers to the evidence. Start of 45, the compelling evidence. You see that? (47) Taken in the round as a matter of planning judgment, I find the appellants provided compelling evidence which justifies the use of BNBL. Yep. See that?
Yep.
So, is there any doubt in this case the inspector was aware of the 2015 WMS?
No.
Is there any doubt the inspector was aware that compelling threshold was the relevant threshold to be applied?
Not in this case, no.
Is there any doubt the inspector applied that threshold in this case?
No.
Is that approach inconsistent with the other two cases we've just discussed?
I can't talk about the last one because the last one there was a lot to take in. That's why I was hoping to take it.
We called it quits on that one.
To take in, and I was, and to some extent, I think it was a little bit unfair to ask me to answer questions
about the wording of an appeal decision that you referred to in your proof of evidence. I don't think that's unfair.
Okay.
I took you quite fairly to all of the relevant paragraphs.
Yeah,
I asked you to agree with me. You can disagree with me, that's fine.
No, that's fair enough.
Okay. But the inspector's taken the compelling evidence threshold in this case, you agree?
Yeah.
Yeah, okay, fine. And my learned friend referred to it already today. You'll recall the Lullington appeal.
Yeah.
You're aware of that. I don't know if we need to turn it up. Will you agree with me that the parties accepted that the WMS was extant and there was a need for justification by compelling evidence in that case?
I'll take your word for that.
We can, let's look at it. It's only fair. 747, please. Paragraph 8.
Right. 7.7.
7.47.
Yeah, both parties agreed that the WMS was extant.
Okay, so let's just sum up that line of questioning. The basis for the reason for refusal was that the appellant had failed to demonstrate compelling evidence.
Mm-hmm.
The first line of attack in your proof, if I can put it that way, was there's no requirement or reference in any of the current or local policy to justify use of BNB by the most compelling evidence. And you say it wasn't correct for reason for refusal to even refer to it at all. That's what you say in your proof, right?
Yeah, I'm saying that's out of date.
Well, we've just been through the PPG. We've been through the approach of 4 other inspectors in 3 cases that you referred to, and we've referred to an agreed position between the parties in the Lullington case, which you didn't refer to, as to compelling evidence being the relevant threshold. That's the state of the evidence. You agree with that?
That's true. All these decisions predate the indication that the PPG is going to be updated.
Yes, but we've already discussed.
I know.
We just discussed the terms in which the PPG is going to be updated,
Yeah.
and you agreed with me, I think, quite fairly that at the very most we can't say. At the very best for you, we can't say which bits are going to be changed. At the very best for us, different bits of the PPG are going to be changed. The bit that you say is out of date.
Mm.
That's what we discussed. Okay, so it's not a case of that 2030 action plan, 2040 action plan materially changing things, is it? This is how inspectors are approaching this threshold now.
Yes, but as I say, all these decisions, they predate the indication that the acknowledgement from central government that the PPG is out of date.
Some questions here for Mr. Cusson. Sorry, I'm just skipping over them. compelling circumstances, compelling evidence was found in the cases that you referred to. Do you know what the percentages of B&B land were involved in those cases?
Not off the top of my head, no.
Do you know whether in any of those cases the total site was comprised of all B&B?
Not that looking at them, but I suspect not. Otherwise, you wouldn't be asking the question.
No. We can go to it if you like, but in Cheveney it was 47%, Poplar Farm 55.8%, Thaxted was 85%. Now, assuming I'm right about that, in none of those cases was there a proposal to use all B&B, was there?
Assuming you're right, then no. Then.
And you agreed earlier, applying what you agreed earlier, I should say, we'll need greater justification in this case, won't we? Because it's necessarily the case that we're using 100% B&B land, we're using more B&B land.
Well, not necessarily. It depends on the grade of B&B, because the 2024 written ministerial statement gives greater weight to highest grade. So a grade 1 site, even if it's only using 20% grade 1, would probably have more weight than the 60% subgrade 3A site. So does depend on the actual classification, not just the percentage of B&B.
That's very fair. Assuming that they're all a similar mix to this development, it will require greater justification, won't they?
If they're all 3A, as we are.
I don't want to go through the exercise of looking at all of them. I'm asking you to just assume.
But if they're all similar quantity, and similar proportion, but other sites have more lower quality land, then I mean that's a consideration clearly. That this land is 100%, virtually 100% 3A.
And of course, in none of those cases, the cases that we've been through, did DES 7, the policy DES 7 apply?
No.
I'm not going to do that. That's just a custom question. Okay. We are, I think you might be pleased to hear, out of the appeal decisions for now. So we'll get on to some of the factors you've asked the inspector to take into account, whether there's been a justified loss of B&B. So the first thing I want to talk about is whether loss is permanent. You recall that issue? We accept that whether or not 40 years is considered to be a loss, temporary, permanent temporary, is a matter for planning judgment for the inspector.
For the 40 years?
Yeah.
It's.
I know what you say it is. Will you accept that what it is a matter for the inspector, how the inspector approaches 40 years interference with or loss of B&B? It's a matter for her, isn't it?
Well, clearly, it's a matter for her judgment. It's everything.
And we'll go back. You just say that. We'll go back to CD 7.23, which you probably still have open.
What's that?
CD. It's actually another appeal decision.
No.
Yeah, it's way too soon.
$732.
723. We've got the inspector there saying 40 years represents a long-term generational change. Yeah, I accept entirely the inspector goes on to say a development would not represent a permanent loss. We're certainly not arguing that 40 years is permanent. Sorry? Oh, 108. Sorry.
Yes, certainly.
Did you see that? First sentence?
Yeah.
Do you want to read all of the para? I don't want to.
That depends what your question is.
Will you accept that the inspector there has referred to 40 years as being a period of generational change?
Yeah, long-term generational change, but not permanent.
No, I know. I'm not saying it's permanent, but it's open to an inspector, isn't it, to, despite the fact that the duration is not permanent, nevertheless find the period of alteration is so extensive as to amount to loss of the particular resource that's in question.
Well, no, because I think the resource is the resource. It's not the length of time. The resource is the land and the soil. And a loss of agricultural land comes around when it cannot be reversed to agricultural land. So,
Well, no,
if it's built development, that is a clear loss of the natural resource. If it's used for something, be it solar, be it golf course, be it whatever non-agricultural, it's not a loss. It's used for something else for a time-limited period.
BMV is not being used in the same way, proposed to be used in the same way as it currently is in the course of this development.
It's not used to produce food, no, but the natural resource remains.
Yeah. Okay. And we have the Natural England comment to that effect, that there'd be a drop in the food production.
Yeah.
Okay, and let's go to the Longfield decision. That's 718. Arrow 7.3. Do you see there? I hope you'll take it as read from me. This is about 40 years. We can go to the paragraph if you like, but it's about 40 years solar development. And you see there the references to temporary long-term loss, right?
Yeah.
So you can see the point I'm making. We've got generational change in one respect, long-term loss in another.
Yeah, they've got the permanent loss there of 6 hectares, which I assume is development.
I think that is, yeah. The rest of it's about a solar farm.
Yeah, and then temporary permanent loss of 150 hectares of
Yeah.
BMB. That describes as a small amount of negative waste.
Yeah, I know this. .3. And let's go then. Do you have the Lullington High Court case? One of those extra docs that I put in?
Yeah. I haven't read it.
No, don't worry. Only paragraph 25 that I want to read out and explore with you. Have you got it up?
Yeah.
Paragraph 25, do you see that? Mm-hmm. In this case, in the case of application, oh no, read the wrong bit. Inspector found indeed, concerning the period of 40 years, it appears to me as it has done to other inspectors at appeals cited by the council, 40 years would indeed constitute a generational change. So you'll accept that 40 years is a period of time which is capable of being considered as, or should I say, the interference with a particular resource for 40 years could be equivalent to losing it.
No, I don't agree with that. It's a generational change, but it's not a loss. That's a resource.
Well, I know what you say in this case. I know that. Got that. But you'll accept, won't you, that that's how inspectors have approached the issue?
Well, they just refer to this is a generational change. It doesn't say a generational loss. It couldn't be a generational loss because a loss would be a permanent loss anyway.
All right. Well, I can make submission on that. That's okay. We know, don't we? The NPPF gives support for extending existing renewable sites. Do you recall that?
Yeah.
So there's strong policy support for extending the life of an existing renewable energy development. Yeah. You know that?
Yeah.
So it's possible that once established, the farm may be there for longer than 40 years.
Who's to say? I mean, somebody would have to go through this whole process again.
Didn't ask you whether it would happen. I asked you whether it was possible.
It's possible. It's possible.
Yeah. So it's not necessarily the case that this solar farm's only going to be there for 40 years once the solar use is established, is it?
Who knows? I mean, really, who knows?
Well, I know, but you've got to say yes or no before you. Who knows me?
Who knows if solar's going to be the relevant, the most efficient technology in 40 years' time? Probably not.
Looking at the policy support for the application as things stand, that's a fair statement, isn't it?
No, because this application is only about this. But this appeal is only about this application. This only applies for 40 years. Well, only 40 years, but it applied for 40 years. It's time limited permission.
Right. Now let's talk about soil health. You refer to the proposed seeding of the site, right?
Mm-hmm.
I think your point is that there are benefits to converting arable use to pasture.
Yes.
In terms of soil quality.
Yes.
And the evidence that you refer to is not in the context of a solar development occurring concurrently with a return to pasture, is it?
No, it's a general conversion of arable land to pasture land.
Yeah, throughout the principle.
Yeah.
And there's no study that I've seen in the evidence about the long-term effects of a solar farm operating concurrently with any pasture.
No, there are studies ongoing. I know that much because I'm involved in them, but solar farms are 10 years old at the most. So studies are ongoing, and it's something that developers take seriously. So, yeah.
So you can predict, can't you, that there's going to be some benefit to the soil by returning it to pasture use, but in the key document that you've relied on, you've missed out a relevant bit of the picture, haven't you? Which is that there'll be a solar farm there concurrently with the pasture use. Yes?
Yeah, there will be. Yeah. That won't affect the parameters I'm looking at in terms of soil organic matter, soil carbon, and soil moisture.
But as a matter of empirical evidence, we don't know that, do we?
I think you probably do, actually.
It's not referred to in the evidence in support of this appeal, is it?
Well, no, I mean, the 25,000 samples, I mean, who knows? They might well have included samples from solar farms. They
don't say so,
but they did.
Okay.
We would have sent, we sent several samples to the same laboratory during that period. So.
Okay. Let's go on to the sheep. It's not secured as part of this proposal as I currently understand it. I think the language in the condition is grazing or cutting. Is that right?
In the LEMP.
Yeah.
Yeah.
So it's not currently confirmed to be grazing.
Well, you wouldn't
Yes
want
or
to
no?
restrict. No, it's an option at the moment, because in management terms, you would not want to restrict yourself to just the one form of management. You'd want to keep your options open.
Well, precisely. So we can't guarantee there's going to be grazing of sheep, can we?
No, but
If you're not preparing
it's
to.
a preferred means of management because it returns manure to the land. It's a good means of fertilizing the soil without having to import fertilizer. It's a positive management approach to take.
My point is, how can you possibly refer to the benefits of this grazing if the grazing isn't something that you have to do?
You don't have to do it. It's a great benefit of it. It's probably easier than cutting land. It returns nutrients to the soil. It would be the preferred management approach in dealing with the grass in the autumn, winter, and early spring.
If it's a benefit, it's down to you to secure it, isn't it? You've got to show us how you're going to secure this benefit.
Well, that would be through the land.
Yeah, but as you just said, it doesn't currently confirm that grazing will occur, does it?
It confirms that grazing will be, one of the two management regimes for the land, and it might not necessarily be the case that you would sheep graze the whole thing at one time. You might just graze parts of the site at any particular time, let others sort of grow through. You would want to give a variety of management options.
But of course,
available.
if you didn't actually use one of those management options, i.e. the grazing option, all the benefits you refer to from grazing wouldn't arise with it.
No, but that isn't going to extend over a 40-year period. I'm talking about within an individual year. In an individual year, you'd want the option of shall I cut it or shall I mow it with shall I graze it with sheep?
Yeah. Okay.
There could be all sorts of reasons why you wouldn't want to cut that year, or why you wouldn't want to graze with sheep that year.
And insofar as there are some soil benefits from returning the soil to pastoral use, maybe having some sheep there, you don't need a solar farm for any of those benefits, do you?
No.
Okay. I think the point that you were making in this new issue here is this: the site makes up a little contribution to arable yield. Remember that? You say the site doesn't contribute much to total UK cereal production, no? You remember that?
Yeah.
None of that affects the policy approach rather, to the proposed use of BMB, does it?
No, but it does. It does result from the wider discussion around the use of BMB for solar, and the ministerial statement, for example, which the 2024 one, which is clearly that there's been a concern about food security from members of the public, members of Parliament, which resulted in that 2024 ministerial statement, and about the effects of using agricultural land for solar instead of food production. So it is a relevant consideration. And it does need to be addressed. And there's a lot of misinformation flying around about the use of agricultural land for solar power.
The value of BMB land in policy, indeed in the local policy, not dependent on size of the parcel of land or the contribution that the land might make towards any total UK food production statistic?
No, it's completely concerned with the natural resource. It's concerned, the policy is concerned with the quality of the natural resource.
And actually, even if we had a site that was say it's 10 times the size, you could still make an argument that the BMV actually contributed 0.00, I don't know, 5% or something.
Yeah,
it would still be minuscule. But in that context, you'd be losing 10 times the amount of BMV, wouldn't you? So it's not persuasive to refer to this site as contributing a small percentage to the UK food production statistics in the same way, is it?
Well, I think it sets a context. And with the concerns about the impact of these types of proposals on the UK food security situation, I think it's helpful to set the context.
I appreciate it might be part of the picture. Will you agree with me it's not in and of itself a persuasive factor?
Well, I think that can be expected.
Well, I'm asking you.
I think it's persuasive, otherwise I wouldn't bring forward as evidence.
But you've agreed with me that we've got this 10 times analysis point and it doesn't make any difference, but you'd be losing loads of BNB land there. I mean, do you not see the force of that? You have agreed. Your first answer was, well, yeah, fair enough, it's set to context. You sort of agreed with me that it wasn't really particularly persuasive. I accept that you want to rely on it as part of your case. Will you agree with me that it's not a particularly persuasive part of your case? It can't stand on its own.
It wouldn't stand on its own. I wouldn't bring it forward just on its own. No. But it's not. It's part of the case.
Yeah. Okay. We discussed earlier the farm. It's a long-standing business. Yeah. It's been profitable until the last couple of years. Is that right?
Yes.
Yeah. And it's only in the last, since the late Victorian time, that has become an issue, as far as you're aware. Is that right?
Well, I don't know.
Well, I mean,
I don't know. I don't know. I can't say it's.
We haven't produced any evidence to the contrary.
I haven't looked at the accounts. This I'm relying on the information that's Sherburn provided with the in the agricultural appraisal report and discussions with the farmer. I haven't gone back in looking at profitability in the last 100 years.
Okay. I mean, I suppose if it was a struggling farm and profitability being an issue, would have been included in your evidence, wouldn't it have been quite useful for your purposes?
But it
hasn't been.
But it hasn't been. But the situation is that it's a farm that's been doing okay, but it's been doing okay because it's got diversified income to prop it up.
That's relatively recent, though, isn't it? It's diversification.
No, since 1990.
Yeah, that's what I mean by relatively recent in the context of, I don't know, 100 years or so. Right, okay. Presumably, there are other diversification methods than solar farming, aren't there?
Yeah.
Can you just give us an example of some of them?
Things like other use of buildings, so things like farm shops, for example, other use of land, so golf courses, cross-country courses, any sort of leisure facilities, dog walking, anything to do in woods,
So there are other diversification methods that are open to this farmer. It doesn't just have to use this particular part of land for solar farm.
Well, they did actually commission a a review of their diversification opportunities.
Is that in the evidence?
No.
Right. Okay.
Do you want to hear it or not?
No.
Okay, there wasn't much available.
Okay.
Is the answer, but no, I haven't brought it forward as evidence. So,
No.
but they have continued to look at diversification opportunities, and there are actually many identified for this particular fund.
Mm. Do you remember the document CD 1.15?
That's about the Sherman.
Yeah.
Yeah.
You just tell us when that document was generated?
20. There you go.
About 4 years ago?
Yeah, 21. November 21.
Okay. So no doubt other diversification methods might have been successfully pursued in the last 3 or 4 years.
On this one?
Yeah.
No, there haven't been any.
Been none in the last 3 or 4 years, neither from the massive list that you referred to.
Yeah, I said they did commission a review of their diversification opportunities.
Remind us how big the farm is?
Well, the area farmed is 1,200 hectares, but not all of that is owned. It's all unlikely to, on tenanted land, you wouldn't really look to diversify that. The opportunity to do so.
Okay. The final part of my questioning is about the availability of suitable lower quality land, which touches on the site selection report, which you'll no doubt remember.
How long are you?
This is my last bit, and I think I might be between 5 and 15 minutes, depending on how it goes.
Yeah.
Is that all right?
Yeah, that's all right. Yeah, I'd like to break back 3:30, really.
Okay. Yeah.
Yeah.
I'll have that in mind.
Yeah.
So the correct approach to how to consider alternatives, if we're going to do so, is governed by the local plan. Yes.
If explain that a little bit more. What do you mean? Like there's 7.
Yeah.
Yeah.
I'm not going to ask you exactly what it says. I'm just going to. Do you accept that it applies for the purposes of consideration of alternatives?
Yeah, that's okay.
I'm going to pick that up with Mr. Cusson. So I want to deal first with reference to how much agricultural land you say there is in the districts. You say there's 57% BNB, leaves us with 43% BNB land. Yeah, remember that?
Yeah.
So there's still a significant amount of non-BNB land in South Oxfordshire, isn't there?
Yes.
It isn't a constrained district in terms of BNB, is it?
It's more constrained than average, but it's not completely constrained.
You agree with me it's not significantly constrained?
No, I think 57% is a high proportion, actually.
How many?
BNB.
What did you say?
57% of agricultural land being BNB is a high proportion.
Seriously?
Yeah, seriously. South Oxfordshire is a good agricultural area. It's not, it's well known for having good soils. It's a productive area. It's not a nothing area. It's a well-known, established farming area.
Mm.
So yeah, I think 57% is relatively high.
You've already agreed with me there's a significant amount of non-BNB land. You won't agree with me that it isn't significantly constrained to make submissions on the point, but there we go.
Mm.
Take up the site selection report with Mr. Cusson. Would you agree with me that if the site selection report is materially deficient, the inspector can find that compelling evidence as to the need for B&B has not been established?
No, because I think that the site has to be suitable and available.
I know that wasn't my question.
And so, but finding clearly if there's 43% land that isn't B&B in the district, you would be able to find land of whatever size that isn't B&B. But that's irrelevant because
Right, hang on, hang on.
that is not
Let's do that again.
identified as suitable and available.
43% is not B&B. Sorry, go on, tell me again. Not B&B.
Clearly, if 43% of 50,000 hectares is not B&B,
Yeah.
You can find non-B&B land. Of course you can. But that non-B&B land, has to be suitable for the intended purpose, and also has to be available for the proposed use.
Right.
It's not just sort of, we can go to this bit of land, that bit of land, that bit of land, and that bit of land.
Okay, but your site selection report is about finding land that's suitable and available, or presumably discounting land that isn't. Is that fair?
Well, I mean, to be fair, I wasn't involved in the actual selection of the site.
When did that happen? Just out of interest, do you know?
The negotiations with the appellant with the landowner.
Yeah, when did that happen?
I wasn't involved in that.
Okay, when was your
In
involvement?
that
When did your
process.
involvement start?
Just for this appeal.
Just for this appeal?
Yeah.
Okay. So if there's a problem with this report, the report's materially deficient, and assuming there's a need to provide compelling evidence, the inspector can find that evidential threshold has not been crossed, can't she?
Inspector, as I said before, the inspector can find what she likes. Yeah, the inspector can find what she likes. I don't really understand the question.
Right.
You're asking me to assume something I don't agree with, couple that with something else I don't agree with, and then say, therefore, the inspector will think such and such. Well, I'm not going to speak on behalf of the inspector.
Well, if we could only discuss things that you agreed with, then I'd be for the other side, wouldn't I? So I have to test things with hypotheses, don't I? That's a completely legitimate exercise for me to perform. I'm asking you to play along. You want to be difficult about it, that's fine. But I'm asking you, if compelling evidence is the threshold, and if there are material mistakes in this report, the inspector can find that there hasn't been any necessity for this B&B established, right?
If she so chooses, if she so chooses.
So much of this will turn on what the inspector makes of the site selection report, right?
Yeah, I assume so. I mean, again, that's the inspector wants to get to that report. It's not with me.
Okay. You'll recall the Lullington appeal decision. You may even have it open in front of you still. What's the CD reference? It's CD 7.27. No. Lullington, let's get it up. CD 7.47, please.
Yeah.
Paragraph 16.
Yeah.
It's clear that you see this? It's clear that a robust assessment has not been made of the grading of agricultural land, etc. You see that?
Mm.
And then you see this is all about failure to disaggregate grade A and grade B land. You read this decision?
Yeah.
Yeah. Okay.
And all they mean by grade B, I assume they
Grade
mean
3B.
3B.
Yeah. There are areas where 20 to 60%.
No, that's not correct. No, that's not correct. Grade B is not 3B. In reading that paragraph, it says, pointing out the explanatory note to the agricultural land classification maps sets out that grade B reflects areas where 20 to 60% of the land is likely to be best most versatile land. Those are what you referred to yesterday as the pink maps.
Yeah, I know they're referring to a map.
But
Talking about
those pink maps don't refer to grade 3B or grade D or anything like that.
Okay. I mean, I'll make submissions on what the facts of this case are and how relevant they are. But you've seen there's a criticism of the methodology of the site selection report. That's the first sentence. You'll have seen the next sentence, which is just after the 20-60% reference. This, to my mind, adds to the criticism that evidence has failed to demonstrate there is no land available for this development in the study area of a lesser agricultural quality, contrary to national and local policy. It also does not stand up to scrutiny as the compelling evidence which is sought in the WMS. See that?
Mm-hmm.
So that emphasises the importance that the inspector in that decision placed on the site selection report, doesn't it? And its methodology.
Mm-hmm. Yes.
And that supports what I said earlier about it being open to this inspector to find that compelling evidence hadn't been demonstrated if there is a material error with this site selection report, right?
That is open to have.
Another inspector's done exactly the same thing.
This one has, yeah.
And then in paragraph 22, if we go on, you see, I accept the council's arguments that the evidence fails to demonstrate there are no suitable poorer quality areas of land in the study area that could be used or accommodate the appeal development, save for a broad brush map-based review. In this regard, the appeal proposed contributes to relevant provisions of the local plan policy, the framework, and the WMS. You see that?
Mm-hmm.
So again, that supports the point that I made earlier, doesn't it? And just finally dealing with
We don't know what the evidence was, do we?
just dealing with paragraph 51. Collectively, the benefits arising from the appeal scheme are significant, likely to be quite similar to the benefits of this appeal scheme, solar development, similar policy support, yeah.
One imagines so, but I haven't read the list of benefits in the decision.
Yeah, okay. And then we've got 50% of the site's hectareage being developed with a solar farm, yes, see that? And you see next paragraph, well, yes, sorry, it's in that paragraph, that loss of resource of 50% B&B land was found by that inspector to outweigh the solar farm benefit, if I can call it that. You see that?
Yeah.
Okay, so that's a decision that's reasonably open to this inspector, isn't it? It's a decision, yes, nodded. It's a decision that has been adopted by another inspector, Longington inspector, yes? Yes?
You mean adopted?
Well, the Longington inspector took that approach didn't they?
Oh, so
Yes? Yeah. And that was the approach they adopted when 50% of the site was being used in B&B, yes? And the position in this case is that 100% of the site will be in B&B use, yes?
it's an unusual decision though. It's an outlier of a decision.
Those are my questions. It's 3:30.
Thank you very much. Do you want to re-examine, but should we have a break first and then come back? So if we come back at 4:45.
Do we do 2?
Yeah, I was just
Sure.
gonna say to it, yeah.
Should we offer? Is that what we're doing?
Yeah.
It's kind of what I was driving at.
Would you like tea?
Yes. See. Decaf.
No, I think so, yeah.
Do you know who that guy? Is that not the farmer that's gone out of the...
Right.
Yeah, this is another of the...
If not, I'll come back.
Oh, okay. He was just sitting behind you and he's going, I'm asking you a question, trying to get... He's just shaking his head in the background. Very distracting. Right, should we go and...
Yeah.
What the tea order?
Can I get injected?
Sorry.
I can see it. Yeah, it's just... Yeah, thank you.
Anyone else?
No, thanks.
Yeah, of course you can.
I'll come with... Should we all go? Because then we can
Yeah.
walk and talk.
applied to different types of policy and guidance. So if you could go to paragraph 38.
Yes.
So you see there, both the policies and the NPPF and the guidance are capable of being material considerations, and you accept that, don't you? The weight to give such policy or guidance in a planning decision is a matter for the decision maker, subject to the court's intervention. And then paragraph 39 sets out relevant factors in assessing the weight to respective terms of the policy and guidance, and whether they sit easily together. So first question, do you think the policy in the NPPF paragraph 187 sits easily with the written ministerial statement of compelling evidence, or do they adopt a different approach?
No, they don't sit easily at all.
So the first point is whether they sit easily together. The second is the timing of their publication, including, for example, whether the policy emerged before the guidance or vice versa, and how recently each was issued. So in this case, was the PPG issued before or after the current NPPF that we have?
It's like being an optician, isn't it? It was issued before in 2015.
And the next bit there, of paragraph 39, another consideration about how much weight you give it, is the nature of the process by which they were produced, including, for example, the fact that the guidance in the PPG is generally not subject to any external consultation, whereas the policies in the NPPF are. So here, I mean, clearly it says exactly there, the PPG is subject to a different process, less consultation, and that can affect the weight to be given to it.
Well, yeah, I mean, especially, when you've got to see also the ministerial statement, which, arises out of a particular set of circumstances at a particular time.
And so in your view, what should attract more weight, the 2015 written ministerial statement or the 2024 NPPF?
Well, clearly the 2024 NPPF.
Thank you. And you were also taken to a number of appeal decisions, CD 7.23 Thaxted, which I think we said was 83% BMB, 7.29 Marden, CD 7.43 Poplar Farm. And if you remember, it was put to you that all of those are solar farms on BMB land. And it was said the inspector had regard in those cases to the written ministerial statement. Do you remember that line of questioning? So are all of those decisions ones where the appeal was refused or ones where the appeal was granted?
I think they were granted.
Yeah.
Don't even know.
And so that's right, they were all granted. So was use of BMV considered a barrier to solar development coming forward in those cases?
Not a barrier, no. It was given weight, and the weight probably varied in each case, but it wasn't a barrier.
And in all of those cases, if you don't remember, we can go back to them. But did the inspectors consider the need for renewable energy since 2015, the government guidance and all of that, all those paragraphs you were referred to? Was that need for renewable energy itself found to be compelling evidence in those cases?
Yes.
And if we just take up one of them, so that we do make sure we refer to the documents, Marden CD 7.29. And if we go there, you went there already, paragraphs 51 and 52. So, I mean, paragraph 51, accepted by the council, renewable energy carries substantial weight when taken alongside the imperative to ramp up energy and the urgent need to address the effects of climate change. I'm satisfied there's ample compelling evidence for the use of this land. So in your view, is it possible to demonstrate compelling evidence for the use of BMV without a site selection report?
Yes, on the basis of that decision, yes.
And you'll recall we also have the High Court decision in Bramley, if we could just quickly go to that, which is core document 7.11. And paragraph 4 sets out the grounds of challenge to the inspector's decision there. And the very last one, number 7, is it was alleged that the inspector had erred in law by failing to take into account a material consideration, namely a lack of alternative sites being considered. Do you see that? Mm-hmm. But we've seen what the High Court thought about that. That ground of appeal was not upheld. And the High Court's decision starts at paragraph, well, the key bit I want to refer to starts at paragraph 179. So what does the first paragraph sentence of 179 say?
I agree with the Secretary of State's PSL that PBG does not mandate the consideration of alternatives. Still less does it require a sequential test to be adopted.
And if you scroll down then to paragraph 185, you see the inspector, sorry, the judge dismisses this ground and says in view of the conclusion that there was no requirement for a sequential approach to alternative site selections, the inspector didn't even have to address the evidence on alternative sites. You see that there?
Yeah.
So you were taken to a number of appeal decisions where the inspectors referred to the compelling evidence test, where they found compelling evidence in the renewable energy emergency and the myriad of government strategies that have shown how much of it is required. And there's obviously a number of core documents in the appeals where the inspectors don't refer at all to the compelling evidence test. And just picking out a couple of those, there's CD 7.60, very recent BESS appeal at Walsall. It is just one example. But I think what's a useful appeal to go to, just to show the other side of the story, is the one at Penhale Moor, which is core document 7.37. And it's interesting, so this is a decision of Inspector Baird from July of last year. You just take up paragraph 18. So here he says, he wants to draw some conclusions from given the 2015 written ministerial statement is extant, the statement of common ground. So there the council and the appellate both agreed no weight could be given to or reliance placed on the 2015 written ministerial statement and PPG. They were published before the framework, the Energy MPS, the Climate Change Act. While the 2015 WS refers to the most compelling evidence, the framework says something else, EN3 says something else, and the 24 written ministerial statement says something else. And the inspector says he agrees with those parties on this matter. So how does your professional opinion about the weight to the written ministerial statement compare with the approach the inspector took in the Penhale Moor case?
Well, I would agree with both of those parties and with the inspector.
And so then you were asked a bit about the conversion of arable land to soil.
Pasture.
Yes, a conversion of arable land to pasture, about the impacts on the soil from that. And you spoke in chief about some of the benefits of turning arable to grassland. Can I ask, do those benefits of resting from intensive arable production only apply if sheep are grazed, or are they more general when there's conversion to grassland?
They're more general when there's conversion to grassland, that you need to manage the grassland. And sheep is a good way of managing the grassland.
And here, the landscape and ecology management plan condition, and does that give the council an ability to control what's in the LEMP?
Yes.
So is the LEMP that's in the core documents the final LEMP, or is that a
No,
draft?
it's a draft.
Draft LEMP. So the final question, you'll be glad to hear, relates to the prevalence of non-BMV land in the area. And I think what you were saying in response to Mr. Clapp was that while there's 50% BMV, yes, there's 43% non-BMV, but that land could be subject to all different other kinds of constraints. Is that one of the points you were making?
Yeah, I was trying to say that its existence itself doesn't make it suitable or available.
And we have a sort of general high-level piece of information about some of the land in this district, which is potentially relevant. And do you have Mr. Cusson's proof and appendices? Do you have his appendix 5? Page 28 of his appendices, which are bound separately.
Yeah.
So this is a document, I think, produced by the council about South Oxfordshire. So you see the second paragraph there. The northeast of the district forms part of the Oxford Greenbelt. In total, around 70% of the district has a Greenbelt or AONB designation. You see that? And then below that, it talks specifically about sort of protected areas and how much of the entire district is AONB. Can you see that?
42% of South Oxfordshire, 23%
Yeah.
of the
42%. And can you see on the right hand side, it says about internationally important, nationally important sites for nature and locally important sites for nature. So how many sites are there that are important sites for nature in South?
There's 4 internationally important sites.
Yeah.
So 38 nationally important sites and 126 locally important sites.
Thank you very much. Those are all my questions.
Much. Mr. Field, you can stand away. So it's just gone 4 o'clock. So we can start this proof of evidence, or we could do conditions. My concern, my issue is that I want to be able to get Mr. Cusson done tomorrow morning, so we've got the afternoon free for the, for the site visit. I don't want him hanging around till Friday. So, given, we're starting at 9:30, so we've got. Will that be enough? At the moment, we've said 3.5 hours. So if we started at 9:30, that would just be possible to get through by 1 o'clock if those timings are still expected to be reasonable.
Yeah, so what did I say an hour?
You said an hour and a half examination.
Yeah, it's not going to be more than that.
Right. And 2 hours for cross-examination. So we could do 1 before and break for and then do the cross-examination afterwards. And so if we think we can get that done, then I suggest we don't start because now leave him free to talk to people tonight, and just do the conditions now, and then do the site visit tomorrow afternoon and closing on Friday. Is that all right?
Yeah. And there is something about the conditions. So obviously there was some cross-examination about whether the grazing is secured in this case. The reason a specific grazing management plan hadn't been included is because there's a proposal for the length which is to be agreed by the local authority, and the appellant had thought that was sufficient. Other appeals, there has been specific grazing management plan conditions. Sometimes the inspector thinks it's not necessary and doesn't apply it, but there are some when the inspector has imposed such a condition. The appellant is fully willing to put a grazing management plan condition forward. And there's one example in the appeals where that has been done at Thoroton in the full documents. So what we were going to propose is we're willing to have that if you were to consider it necessary, and to add that on to the bottom of the conditions as an optional.
I have one up my sleeve as well.
Okay. Yeah.
Which was the customer note, because it was one discussed at the one in last May. We had a
the authority was the same authority, so it may well be a as well.
Yeah, I mean that was that was dismissed in the end, but I mean it was we had discussed it, so I do, if it needs to be, so I've got word in it once, so
But the point is the appellant's willing to accept.
well we can discuss that in a minute. If we just want to go through the conditions, just bear with me to get them. And it may be, I mean, if anything should come out of Mr. Chris's group tomorrow, we may, that is something else we may need to pick up. I mean, and hopefully we've got all things covered, because I mean there is suggested conditions at that point anyway. So
did you want to go straight into the conditions?
I think so, yeah. I just need to get them up.
We'll sit here and make it.
So I mean, I'm hoping with this, I mean, we've got we've done quite a lot of work on these already, and by exchange of various messages, and we've got this kind of table which sets out and that. So my plan is, where it's agreed not to bother discussing, take it as read, but that is agreed, and I haven't got
Has this made it onto the website?
That's a good point. I don't think the latest version has.
But this is with the table is the one that was circulated this morning.
Yes.
Yeah.
Yes.
Do you have any other copies of that?
I can run one off now.
Okay.
The table or the conditions list?
Well, I don't know if worded. So the latest I have is the one that was sent to Pins last night. Is that?
No, there's another one.
There's a slight update just in respect to the two archaeology conditions.
Can you send that to me? Do you have it?
Yeah.
Okay.
There's no change. The county archaeologist has agreed the wording as.
I just want to make sure I'm starting this session on the same page.
Do you want me to print your? I gave you guys 2 copies this morning. Do you want another one?
If you have another one, that would be great, but we can get started without it. That's fine.
So on to print now.
I've got good one using that.
Okay, great. Thank you.
I've just emailed it.
Okay, we've all got that now. Thank you.
Okay.
So the first two, we're adding the extra planning on the plans one, but other than that, no problem. The temporary permission, I mean, I've just raised about that bit, the last sentence, and whether it's needed. I just wondered if the LPA can explain why you consider it needs to be in there as well as a condition at the end.
Yes, we would normally put it in both conditions, acknowledging that it is repeated in the decommissioning method statement at the end, just to put up front that it is a temporary permission and it needs to be removed from the site within 12 months of it ceasing. I do acknowledge it's a repetition of the condition at the end, but the way that we set out conditions by its nature the decommissioning statement is very low down on in the condition, so we're putting up front that it needs to be removed within 12 months of
Yeah, you kind of set it out in kind of
in chronological order.
Yes.
So
I mean, sometimes everyone does them differently.
Yes.
Sometimes the decommissioning one comes straight after the temporary permission. So
Okay.
that's probably why it's not repeated. But
yes, sure.
So I mean, you accept that it's just repeating it.
It is, yes. It is repeating it.
I mean, do you have any views on whether it needs to be in or not? And then
I don't think we have a strong view if we're going with your choice on it, really.
right.
Yes, likewise. It is secured by the condition later on.
Yeah. Right, well, I'll just leave it to me. And then the landscaping's number 4. So I think I suggested that the planting should be implemented in accordance with the approved details and implementation programme. I think the appellant suggested that they agree with that. But the LPA haven't. I just, again, do you want to just explain?
Yes. So in terms of the implementation programme, it needs to be specified that it's in the first planting season available after the first export date. If the management, if the programme, contains a different date, it wouldn't be in accordance with that. So to specify in the condition no later than the first available planting season, rather than leave it up to the programme to be put in as part of the implementation programme.
Well, you wouldn't agree the programme if you didn't agree the timescale, would you?
No, that's correct. But to be specific in the condition and precise about what we're looking for, we add that wording in.
I mean, I would still say it's precise without, with just saying that it accordance with the approved details and implementation programme. Because I say you wouldn't approve the implementation plan if it wasn't acceptable. So, but I'm not that fussy though. I'm not. And then the last bit is just about whether you've raised that it maybe that the reason the tree or plant failed was because it's the wrong species in the wrong place for it.
Yes, we don't want to restrict ourselves to exactly what was previously put in, because that might have been the reason why it failed. So
yeah, I was just trying to avoid you having to get a lot of things to have to reapprove in writing. Given we're regularly told how much pressure local authority planners
that is true.
Departments
yes,
are under.
That is true.
And the more you have to approve, there's more work for you. But
yes, that's very true.
But I think happy to leave it to my discretion which way to go on that one as well. Yeah.
I would say, it's already been approved in writing with the same tree, and you'd have to go back and change it and agree it anyway if you were doing something different.
Yes, that is.
So it's kind of implicit.
Yeah, I think leave it to your discretion, Mark, but I think there's potentially a danger that we could just see the same tree failing over and over again, but that might only happen in occasional cases.
Yeah.
So yeah.
Right. Is that no 5 is yeah, I mean, I questioned about the timing, but your landscape officer wants it in at that, and I think you've not got a particular issue with it coming in at that stage. So just the other issue is to do with the hedge height and whether we need to specify the hedge height.
We wouldn't normally specify the hedge height unless that's already been kind of considered through the planning application. It would need perhaps a more detailed site survey of what's required where, because there might be different hedge heights. For example, Mr. Cook yesterday was talking about 2.5 metres adjacent to roads, 3.3 metres internally. There might be other areas. So rather than kind of going into specific detail there, we wouldn't normally do that. But if you wanted to do that,
quite often on solar farms they are, because it's part of the whole ethos of like being high enough to, you know, keeping the hedges high enough so you don't see the panels. So I mean, that, you know, that's it's often a critical thing to secure.
I was just going to say, sorry, it says on the landscaping master plan throughout what height the hedgerows are going to be at.
Yeah.
To obviously control through the approval of the approval of that plan already. So we specifically say along the western boundary that they'll be at 2.5 metres.
Right, yeah.
And then elsewhere across the site 3 metres.
That's the revised landscape master plan.
Yeah.
Okay, and so our landscape officer has looked at that and not raised an issue with the height. So I can assume that what's specified on that plan is acceptable.
Yeah. And
there's no objection to including provision about which height in that.
Yeah.
And again, at the risk of repetition, you've already got the landscape master plan referenced in condition 2, but put it in.
Yeah, I mean, it's just
yes.
And yes, you've got to submit a management plan. I was trying to help to look at other condition. Yeah, I mean, this one I've got, it said it requires a landscape management plan, which it just says, including the establishment and thereafter maintenance of the hedgerows to a minimum of 3.3 metres high. So I mean, it's got that. I mean, obviously here we've got 2.5 or 3 metres, but it just double kind of, you know, it depends. I mean, I guess how important it is to you in terms of the landscape impact that they are. It is determined to be at that height.
Yeah, it is. It is important in terms of landscape impact. You talked about the hedges being sort of creating that containment of the site. So yes, it is important that they're maintained at
Right.
at minimum height.
Well, I think we probably need to just put
Yeah,
another requirement in, something along those lines. But well, I can't say along those lines because it's a pre-commencement condition, isn't it? So we need to have it bottled down.
Just to say of a minimum of 2.5
5 meters, yes. So so including, so it needs to put in ensuring the establishment and thereafter maintenance of hedgerows at a minimum of 2.5 meters high.
Whereabouts is that? Sorry.
I'm going to put it so, and C, so make C rather than in between B and C as it is at the moment, add in that it shall include ensuring the establishment and thereafter the maintenance of hedgerows at a minimum of 2.5 meters high.
Do you want a reference to the landscape master plan in there, because conscious that some are higher than 2.5 within the site, just to clarify that some of those need to be
so we could say
maintained.
Thereafter the maintenance of hedgerows at a minimum of 2.5 meters, or do we just want to say in minimum of 2.5 meters and in accordance with the landscape management plan, and put the reference in. That okay? Yeah.
Sounds good.
6, the access one is okay. 7, the construction traffic management plan has been submitted, actually, hasn't it? So do we need another one submitted?
The county council requested one to be submitted, but I would have assumed that they would have looked at all the documentation that was submitted with the application. Bear with me.
I'll double check, because sometimes the CTMP doesn't go to the detail of the requirement of wheel washing, which
it does, doesn't it? Yeah, it does. I did have a look at it. It does. It does set out everything that it says needs to be.
Can I just say, while he was looking for that, this is Henry Scanlon. I didn't introduce him to the inquiry.
Yes, I will need to put both of you on to it because you're speaking.
So I've written his name and his qualifications.
Right, thank you. Yeah.
So he's part of the team at Pegasus and he's been working on the conditions. Sorry, I should have introduced that.
What's your title? Are you a planner, senior planner?
I'm an associate. Yeah.
Associate, yeah. Associate planner or just associate? I can't
remember how they put it now. I think they say associate planning is the way it's not says,
yeah.
Sorry, thank you. I should have done that.
No, it's all right. I tweaked who you were. Have you got qualifications you want on the
I can send you those separate.
Well, just write them down for me and give them
I'll
to me tomorrow or something. Sure. It doesn't. I think I've got your title on various emails that have kind of gone between.
I sort of have 2 titles. I'm principal planning officer, but I'm currently acting up as
we'll have
team leader. So that's what
I'm up team leader. It's what you are at the moment.
Yes. Okay.
We're back to the CTMP.
Yeah, CTMP. Yes, my apologies. Having looked at the original consultation response from the county council, it actually doesn't feature in their request for conditions. I think they subsequently asked for it to be added, and I'd have to go back through my correspondence to find the reason why, but it isn't in their list of original conditions. So
it may be that they missed it. They had seen it and then missed it.
Yes.
Or later realised, forgot they'd seen it.
It's in the detailed comments it says a construction traffic management plan has been submitted and appears to be the same as the previous application. It doesn't say that it's required a condition or there's anything amiss with that construction traffic management plan.
So we could just change it to the development
in accordance with the
development in accordance, right? Yeah. Eight, okay with 9. Yes, we've got. So it's a phased programme of archaeological investigation should be carried out in accordance with the approved written scheme of investigation. Programme of work should include all processing, research, analysis necessary to produce an accessible and usable archive and a report for publication, which should be submitted to the LPA within 2 years of the completion of the archaeological fieldwork. That's where we've got to with the wording of that.
Yes, the county archaeologist is happy with investigation rather than mitigation. He has provided an explanation as to why mitigation was used, but if he's happy with it,
right,
so, yeah.
So that one's all right.
Just to clarify, then that if necessary has been done.
Yes, that's correct. Yeah.
So it's a report for publication, which shall be submitted. So 10 on the soil management plan. I think that's all agreed. 11, it's agreed as amended. 12, 13, 14, 15. 16. I understand your comment. Fine with that. It's just I now understand what you were saying. So happy with that. 17, drainage. What do we just do? Oh yeah, just in the sentence that's been added, where we've got the surface drainage works to serve any phase of the development should be carried out in accordance with the approved details prior to the first export of energy for that phase. Is there going to be phases, or is it just online?
Yeah, our understanding was just one phase. I think it was just covering it off in case it came forward.
Right. Yes. I mean, I think so. I've never known a solar farm come forward in phases. I'm not claiming to be the leading expert on solar farms. I'm sure you know more about them than I do. But so I mean, like, do it to serve the development should be carried out in accordance with the approved prior to the first export of energy. Is that?
Yes, that would be fine. Remove reference to phases. Yeah.
Right. 18, right, yeah, I mean, I'd flagged up here whether, given the discussions about sheep grazing, whether we needed anything specifically in there, or whether you want a specific sheep grazing. Let me find one.
It would be useful to see the wording of that, if possible.
Yeah. I can't email it to you. I'd have to email it to the office, and the office would have to email it to you.
Well, if you tell us which decision it is,
Yeah.
Well, it wasn't. It was
right.
So point. Sorry, I just missed it. But it was discussed. It was the decision in May. What was the site?
Kingston.
Kingston. Yeah, the Kingston estate. One. But
Well, should I read out the Thoroton one and see if it says the same as your
just let me
wood
get,
green?
it as you say, I mean, it was the same authority, and so the one I've got says no electricity should be exported to the national grid until a grazing management plan has been submitted to and approved in writing by the LPA. The GMP shall detail which parts of the site shall be used for the grazing of livestock during which months of the year and how the grazing is to be managed. Within 3 years of the date of first export, the grazing of livestock shall commence on the site in accordance with the GMP. The approved GMP shall be implemented thereafter. Any changes to the GMP during the lifetime of the permission shall be submitted to the LPA for approval in writing and shall not be carried out except in accordance with the approved revised GMP.
It's almost identical.
Right,
to
yeah,
this one,
yeah. Well,
so we'd be happy with that.
yeah. I mean, and as you're
So for
Yeah,
the,
we've
Right.
checked with the client.
Right,
You're happy with it.
yeah, for the council's benefit, you want a written version, then it's very similar to the one that's on the
Almost identical.
proceeding.
Good question. I think that's CD 7.39, condition 28 on that. So Thoroton.
Okay.
I mean, I'm happy for you to have a look at it overnight, kind of thing, rather than have to
Sure.
make a snap decision here and now. So if you want to take it away and have a look at, and whether you feel you need that or whether you're happy with, controlling it via the landscape or the length, and you may feel that you can do. So I'll leave that with you,
Yes,
and then
thank you.
to come
Yeah.
back. But I think other than that, I don't think there was any issue with 18 as amended.
Is that condition I preferred to just making an amendment to the length condition?
Yes.
Is there an option for that?
Yes, I mean it's yeah, I mean I'm just throwing it in as an option because it's obviously been raised as an issue.
Yeah.
But you could have a specific policy, I can't get my words out, specific condition for that if you felt it, or you can just use 18, and you may want to alter the wording of that.
Just insert one of the bullets that would just be
Yes.
the agreement of the grazing management.
Yeah.
Within
Yeah.
that bullet with those listed bullets on.
Yeah.
Yes.
Either way, we're
Okay.
Yeah.
Okay. I will take
Yeah.
that away.
Yeah, that's fine. 19 is fine. It's amended. 20. Yeah, I think we just need to put in that the details of as the appellant has put in the wording of that it's just specify the document or the plan specifically. So we're all clear which plan it is that's being referred to that's got to accord with. 21 is the visibility displays. Yeah, it's agreed as amended.
Yeah.
22's all right. So we're asking for decommissioning ones. No, where I'm suggesting that we could just put in, we could change the beginning of 24 and just say within 6 months of the cessation of the export of electricity from the site, or within a period of 39 years following the first export date. Because I think that covers.
Yes.
That covers if for any reason it stops production.
Yeah, I think having reflected on your suggestion, I think would generally be happy with that, because it does cover the what 23 is looking for, and the decommissioning management method statement.
Right, so change the beginning of 24 and get rid of 23. Um, 25 is agreed at the materials, and then 26 is battery storage safety management plan. Are the council happy with that, the wording that's been suggested for that?
Yes, that's fine.
Yeah. And the other one I raised was that Mr. Cook's proof had mentioned about there may be need for some tree canopy lifting or pruning and removal of vegetation for the access, and he said that may need to be secured by a condition. I did mention that previously. I didn't know whether that is needed or not.
I think that is potentially covered, and I don't know if the appellant agrees, but maybe not. By the landscape management plan condition 5, but potentially we can add that in to condition 5, because it's arguably management of the trees on site.
Yeah.
The other one. Sorry.
Yeah, no, go on.
The other one we wondered if it fit. It was already covered in with 16, which is the art management statement specification of pruning tree surgery works. Hedgerows, trees or hedgerows to be removed. So,
yes, actually, that's probably
already
correct.
without any modification.
Yeah.
You think that?
Yes,
that's fine. I only raised it because it was, I tend to pick up when I'm going through anything that's said in a proof that may need to be, conditioned, and I wanted, if that's you're happy it's covered.
That would be covered by 16. Yes.
So I think that's anything, unless there's anything else that anyone's thought of that we need. Yes. No, I'm happy with it. We've covered everything. Right, that's fine. Very much. So that's that was that. So much stuff when we get to sort out quite a line of plans.
I had a minerals scheme recently with more than 100.
Oh no. That's a good reason why I don't do minerals. Section 73 applications. I hate those. Those are that's getting more and more complicated legally, isn't it? And what the panel can't do under Section 73. My advice is just don't bother. Just go in with a proper planning application.
That's what we advise. For some reason they don't like that.
No, Oh no, anyway.
Yeah.
Oh no, yeah. Well, I've been in the High Court over a Section 73, so I've got bad experience. So, I know. So, yeah. So that's everything for today. So we'll resume tomorrow at 9:30 with Mr. Cousins' evidence, and I hope to do the and then get out. I don't know what the weather forecast is for tomorrow. I hope it's reasonable. Yeah. And
so do you, Mr. Cook is going to come on the site visit tomorrow afternoon.
Yeah.
So is your intention to go maybe after lunch around 2 o'clock?
Yes. So I mean, assuming we can get this thing done by about 1.
Yeah.
I mean, yes. I mean, it's a bit difficult to know exactly how it's going, long it's going to take. My intention is to get changed before I go out on site visit because I'm not trotting around in my suit. And from my experience on Monday, wellies are definitely required, without any shadow of a doubt. So, yeah, I would think it would be possibly 2:30. I mean, it doesn't take long to get there from here, but there was roadworks on Monday between here and the site, which was causing quite a bit of a backlog. Now I was there more at rush hour time, so whether it's what it's like during the day, but it might take a bit longer to get there. So, but yeah, so I can't give him a precise time.
No.
Do you want to agree somewhere to meet, or do you want to start from here?
We can get him to come here if that's easy.
Yeah, I mean, it depends what we need to do on an accompanied basis and what you're happy for me to just go and wander. I have already walked up I walked across the footpath that goes across the field from Croft Cottages. I've walked across there. I've walked up the footpaths that go up and then through the wood and pop out on Oxford Road at 3 different points. I've walked those. I'm happy to walk them again if there's things you particularly want to point out to me at those points. You know, I'm not saying I haven't been to Witton and Crumps because the night closed in before I've been delayed somewhat by our motorway network and various traffic jams and getting down here. So I didn't have as long as I wanted. So I haven't been there, but I mean that again, you may be happy for me to go there on my own. Yeah. So I mean, from what I've seen, there's either we meet at the farm itself, if that's okay with the landowner, or I see a nod. Or there's the lay-by on the A415 where a number of cars can park relatively, you know, safely. It's a proper lay-by, so you can stop. So it depends. I mean, I
whichever suits you, I think.
I'm suggesting. I wonder whether possibly the farm building, because I think the thing I probably want to do is actually walk round the site rather than just on the public footpaths, to see, you know, so I can see exactly on the inside. Yeah, because obviously I've only seen it from public footpaths.
Yeah, that's fine.
So possibly, if we need to the farm, and I guess it depends whether he wants to come here and know exactly what's going on, or whether he wants to just sit and wait if we're a bit late. But I would certainly hope it was no later than 2:30 we were there, and possibly a bit sooner. That helps.
That's very helpful. Thank you. Yeah.
Right. Well, I'll see you all tomorrow at 9:30. The rest of it being in isolation. Enjoying all night. So don't know whether you can, if you're still waiting to see about 6 hours. All right. We haven't got.